May I pardon to mention that we have challenged the miller's methodology adopted by the Honorable Claim Commission regarding compensation. The Honorable Supreme Court has directed to dispose of the writ petition within 3 months, millers. The Lordship, you can fix a date.
Similar matter is fresh matter. Connected this.
More than 13 years in custody, madam. Hearing.
After acquisition of land, I reconstructed my house. Thereafter, without in notice, my wall has been barred for demolition and acquisition.
No, once it is acquired, why have you constructed thereafter?
No, after they construct the road, then I constructed my house, madam. Thereafter, they have marked to again to demolish.
No, suppose that has for that particular place was not used for the road. But if a part of the land has already been acquired and you have been paid compensation.
Yes, sir. I have.
How you constructed a building over it?
Madam?
Not follow up. Suppose 4 decimals of your land was taken out.
Yes, madam.
Right? And you are paid compensation.
Yes, madam.
Out of which 2 decimal was used for that road. So 2 decimal is still lying. And how did you constructed the building over that balance 2 decimal? Even after getting compensation for that?
No, I have already been compensated, madam.
Yeah, that is exactly what I'm telling.
They demarcated the land and constructed the loan balance. Thereafter, I reconstructed my house.
Please give it.
Matter related to that the petitioner is a service holder, given a service to a particular property, which is a leasehold property. That leasehold property, the petitioner has given a representation to the authority. They have not disposed of that application. And in the meanwhile, under the IBC, the resolution of professional has taken.
What is your application for?
Because it is leasehold property, my lord. Leasehold property, unless and until the principal will give, the government will give the permission, the leasehold property cannot be enforced.
Okay, give it.
This is urgency.
This matter, my lord, appointment under rehabilitation after my lord.
Petition challenge inaction of the opposite party, my lord, not appointing to rehabilitation assistance scheme, your lordship.
This is the matter listed on the other heading, and I for amendment has been filed.
The matter was stated on 25th September. The Lordship directed the matter will come on 2nd of December. Because inadvertently it has not come for orders.
May please, my lord.
Wait, delete appeal of the year 2020. I am for the respondent. I have filed the writ appeal. But due to pendence of this the writ appeal, I am not getting the retirement benefits.
Please give it.
Modification of orders.
Modification.
Relating to declaration of result. DPUT is not declaring the result. The petitioner is suffering.
Examination result.
Yes, my lord.
When the exam was held?
My lord, engineering has passed.
When it was held?
Held in the 2020. Till then, they are not declaring the result.
2020, the
Yes,
exam.
my lord. Yes, my lord. Because only the practical mark was not supplied by the concerned college.
Okay.
They are not declaring. That is the whole difficulty.
My lord, WPC number 64 of 2025, it's urgent in nature, my lord. The opposite party going to evict in illegality committed by them because there is nothing, any notice applied to us, and they are, by mic announcement, they are going to evict to the petitioner, my lord. That's why, my lord, may kindly take up this matter today or tomorrow.
You are in unauthorized occupation of a
No,
government land.
my lord, they say so.
No, what is your case?
What is your case?
My lord, my case is that since from 50 years, I am possessing this property. That's why government may settle this property in my favor.
Anyway, please give it.
My lord, may kindly take up this matter.
Give it, we'll see. When in accepting, we'll fix a date and maybe.
8th to 20th, I am not available, my lord.
You have given the memo, we'll consider it during launch hour and we'll fix a date.
Much
Please
obliged.
have patience and see.
Much
what is-
obliged.
Okay, yeah.
My lord, one jail criminal appeal, my lord. In this case, the petitioner, he is convicted under section 302 and he is in custody for more than 8.5 years.
Please give it. Okay. Single bench matter?
It's a division bench matter. Division bench.
No, 7 years and over.
More than 8 years.
302 matter. Why did you say that it is a single bench matter? Yes,
Yes, additional and additional materials.
give it.
Plus, my please, also. Plus, one mention with the lordship's permission, plus. As on item 40, there is a matter related to preventive detention under the P10 Act.
Mr. Katkia, little loudly. Your matter is 30, item number 30.
40 plus, 40.
40.
Yes.
Yes.
That matter relates to preventive detention under the P10 Act, and your lordship has been pleased to admit the petition by order dated 26/11/2024 and directed the government of India to file the counter. By now, no counter has been filed, and the petition is in custody since last around 6 months. I humbly pray, my lordship, hear the matter as early as
Is there
possible.
anyone from the side of the Union of India?
Plus,
Mr.
maybe taken up just prior to recess. I will intimate my friend Leonard.
All right, nobody is there now. They have not yet joined. So Mr. Padi is not there. So please wait. When they join, we'll say that it is taken.
Because I humbly pray before this prior to recess, your lordship, I will take up.
Senior is there.
Acha.
Item number
40.
40. WPCR.
Counter was required to be filed by 17th December 2024. And even by now, no counter has been filed. And also it was listed just prior to vacation for 3-4 days. And
Kashyap is appearing in that case.
No, that's all right. But this sort of matter should be taken off in a expeditious manner. Because preventive detention for 1 year.
WPCR.
And if in this
Yes.
process of filing counter and this, that, you take most of the time. And then there is no purpose.
Let me obtain instruction whether their counter is ready and they are filing for. Pass it over.
plus, your lordship, I recall your lordship has directed
Mr. Kashyap is there.
Your lordship, in this case,
Mr. Kashyap.
yes, my lord. My lord,
Mr.
today itself I
Kashyap,
am filing the counter.
Yes.
Today itself I am filing the counter.
You are filing. Please
Yes,
serve a copy on Mr. Katkia.
Yes,
So
yes,
that
I
he
will do
can
that.
file rejoinder if it is necessary. Otherwise,
My lord.
we'll take up this matter next week. Okay,
My lord,
under
my
the
lord.
heading of
Today
hearing.
itself I will do all the necessary.
Right,
It's on the top of the list, your lordship can take up this matter.
You just mention on that day, Mr. Katkia, it will come on next Monday. And you make a mention on that day, we can take up. There is no problem.
Right.
All right.
I humbly pray, your lordship can call for the record, original record. It may be required for the.
Mr. P.K. Padi, Lieutenant Deputy Solicitor General of India. So also Mr. P.K. Kashyap,
SS Kashyap.
S.K. Kashyap.
SS Kashyap.
Please give the name so that you can.
Satyasindhu Kashyap.
Kashyap, Lieutenant Central Government Council. Submits that the counter affidavit will be filed during course of the day.
Yes, ma'am.
Stop. Let a copy of the counter affidavit be handed over to the Lieutenant Counsel for the petitioner also. Matter be listed on 13th of January 2025 for hearing. Rejoinder, if any, be filed in the meantime. The Lieutenant Counsel for the opposite party shall keep the records of the proceeding ready for the purpose of hearing. Yes.
Ma'am.
Right, lordship.
Quickly list item number 1.
My lord, I am Vishal Puri, my lord. I pray 2 week time, my lord, because petitioner already applied the certified copy of the improved order. It has received, my lord.
Right, which is certified complaint. You are not particular. What is the basis on which you say that the order has not been, the officer has ignored this order, this one.
So you have all right, Mr. Trilochan Panigrahi, learned counsel appearing to virtual High Court of Orissa submits that he may be given some further time to obtain instruction as per the order dated T-12/2024. How much time you require, Mr. Panigrahi?
My lord, 2 weeks, kindly 2 weeks time will be granted, my lord.
2 weeks,
Good
time. 6 for 2 weeks time. So basic after 2 weeks. All right.
Okay.
Item 2,
Yes, my lord, Honorable Justice Chitran was appeal committee.
Appeal committee.
This matter before some other bench in which one of us bracketed, Honorable Justice C.R. is not in. Yeah.
item 3,
Item 3, my lord, I pray for some more time to comply with the order dated 12th of September 2024.
12th of
September 2024, my lord, order number 1. Therein I've sought for some time to obtain the instruction whether any distressed family has been provided with the.
Yes, we observed that learned counsel for the petitioner submitted that similar persons have got the relief and drew the attention of the court to paragraph number 19 of the petition, so also to annexure 9 series, but fairly submitted that the projects are different, and so far as the case in hand is concerned, it relates to
irrigation
medium irrigation project at Karanjia, and seek some time to obtain instruction as to whether any displaced family under the DO medium irrigation project at Karanjia has got relief as has been claimed by the petitioner in.
I pray for some more time.
How much time is required?
4 weeks.
Right. Learned counsel for the petitioner takes 4 weeks time to obtain instruction as per the order dated 12/9/2024. List this matter. Shari Shokar for it.
item 4,
Now, this writ application arises out of land acquisition proceeding. I have challenged the order of rejection under annexure 17, my lord. Page 63, which is a non-speaking order, and also, my lord, has not considered the
What is your prayer in this writ petition?
to provide a job to the land house team, my lord. Petitioner's house have been acquired,
Yeah,
and they have given the compensation for that house, my lord.
yeah.
Therefore, as per the RR policy, my lord, they have to provide a job to the family of the petitioner, my lord.
Is it there in that?
Yeah, I have quoted, my lord, in my writ
Which
application.
paragraph?
Your lordship will kindly see paragraph 21A, my lord, page 10. The policy I have quoted in paragraph page 11, my lord.
You said that you have quoted in your writ petition.
My lord,
Which paragraph?
page 11.
Page 11. 11 dollars.
Employment, my lord, the family shall be eligible for the employment by the project causing displacement or loss of any agricultural land. For the purpose of employment, each original family will nominate one member of such family. However, the families as mentioned so and so will not be considered separately for employment. Any one of among those categories may, subject to the eligibility, be nominated by the family as defined in 2F for the purpose of employment. The project proponent will give preference to the nominated members of displaced other families in this matter of employment. That is the policy.
You applied for it or?
Again, applied. They have, my lord, rejected under annexure 12, page 32.
Okay. Why it was
Challenging that, when they have saying that I have constructed the house after the.
Yes.
My lord, my rejection in the earlier occasion
was that they have said that I have constructed the house after the notification was issued. my
Not
lord.
only that, page 33 is the subpara 4.
33
This-
subpara 4.
The similar objection filed by the petitioner under subsection 1.
So, the objection of hearing so and so held on Ethiki in the confidential of Tahsildar under that was quashed, my lord.
No.
This order was quashed by this honorable court
Then,
and remanded for fresh consideration.
where is that thereafter?
Yes, your lordship will kindly see that is annexure. That is annexure 16, page 59. The order is at page
60.
again 61 and 62, my lord. In view of the opposite affidavit, implied so and so. The order of so and so collector under unlawful miscase number and annexure 12 is hereby quashed.
Okay, you come to the operative portion of that impugned order at page number 35.
And that
Last paragraph.
was quashed, my lord.
No. Eta quasi ji, annexure
Again.
12 টা।
Again,
Annexure 16 is at a quasi.
again.
আচ্ছা,
In the earlier writ application.
just.
the sheet. 26/23 order.
Again.
Okay, then after this order was passed by this court on
Again.
51/6/24,
Again.
what further orders have been
That
passed?
is, my lord, that is under challenge, my lord.
What they have stated now?
Non-speaking order, my lord. Your lordship will kindly see.
That is annexure 17.
Annexure 17.
Take down. This writ petition has been filed by petitioner Anjali Behera for a direction to the opposite parties to provide a job to his sons as per the direction of this court in WPC number 15298 of 2023, dated 21/6/2023, and RR policy, 2006, and further to pass the order dated 16/8/2024, passed by the opposite party number 2, collector on board, under annexure 17. The learned counsel for the petitioner submitted that earlier, as per order dated 26/4/2023, the opposite party number 2, while deciding miscase number 13 of 2023, as per order dated 26/4/2023, on the representation of the petitioner to provide employment and compensation on land, house, and trees, etc., came to hold that the petitioner had constructed 2-room asbestos house over the disputed land only after section 11(1) of so and so Act 2013, that is in page number 35, last paragraph. Such type of construction is not within the ambit of 2013 Act, entailing compensation for the said construction. Similarly, leaving only around 90 square feet of land, rest of the plot converted to a pond. The question of availability of different tea growths along with tea well, so and so, এটা পুরা quote করে দেবে up to last পর্যন্ত, তাই না? And also untenable. And accordingly, the claim of the petitioner was held to be devoid of merit and rejected. The petitioner challenged the said order before this court in WPC number 15298 of 2023. And the division bench of this court by order dated 21/6/2024 has been pleased to quash the aforesaid order of the opposite party number 2 dated 26/4/2023 passed in Miss Case number 13 of 2023 and directed the opposite party to take necessary steps for disbursement of compensation amount as well as RR benefit in favor of the petitioner in accordance with law. It is the contention of Ms. Dipali Mahapatram that after receipt of the order, the Special Land Acquisition Officer NTPC on board in a non-speaking order has been pleased to hold that the land compensation amount to the tune of rupees 35,46,091 has been disbursed to the petitioner. As per RR policy 2006, the petitioner is not coming under the displaced family and hence she is not eligible to get any RR benefit. Land counsel for the petitioner drew the attention of this court to the various grounds taken in the writ petition and submits that the petitioner is entitled to get the RR benefits and therefore the rejection order under Annexure 17 is not justified. Issue notice on the question of admission indicating therein that the matter shall be disposed of at the stage of admission. Land counsel for the state accepts notice on behalf of the opposite parties number 123, who is appearing for NTPC or notice. Requisites for issuance of notice by speed post with proof of delivery for opposite party number 4 shall be filed within a week. Place this matter after 4 weeks. Counter affidavit, if any, be filed in the meantime, serving copy on the land counsel for the petitioner. Yes.
Item 5.
May it please, my lord. Petitioners are working as salaried amines under the district justice. Earlier, the association approached with claiming certain relief, which was considered by this honorable court under Annexure 15. And actually, my lord, at page 74, a direction was issued by this honorable court to consider if any fresh representation is filed.
Where is that?
My lord, at page 73, at 74, your lordship.
15. This is the order, earlier order.
Yes, my lord.
On 10/5/2020.
My lord.
Okay.
At page 74, my lord.
Please come to that portion. Paragraph number 5.
Yes, my lord.
At page 74.
Having heard land counsel for the parties and after going through the records, as agreed to by land counsel for the parties, this writ petition stands disposed of, permitting the petitioner to approach the authority by making fresh representation within a period of 15 days. Hence, highlighting the grievances as has been made in the writ petition, so that the authority can consider the same and pass appropriate order in accordance with law, considering the nature of work discharged by the petitioners, and also taking into the report furnished by the City Commission as well as the judgment rendered by the apex court.
Yeah.
But thereafter, they submitted the representation, which your lordship will find at page 75 under Annexure 16.
Okay.
But it came to be disposed of under Annexure 17 at page 83, my lord.
What has been held there?
Here, what has been said that since one of the writ petition again is pending before this honorable court, they avoided to dispose of the representation on merit. They said that we await final disposal of WPC number 6995 of 2020. And that is the exact reason, my lord, by order number 1, your lordships tagged the other matter which was pending before this honorable court.
Okay.
Firstly, my lord, my submission would be that if the entire matter is left to be considered by them, even 6995 of
No,
2020.
what order has been passed in the earlier, that is the
6995.
WPC number?
No order has been passed on the, my lord, I am for that petition.
You are the petitioner in 6995
Yes,
of 2020.
Yes.
So what was the last order passed in that? 8/11/21.
Counter and
Mr.
affidavit.
P.K. Mudli, London Additional Government Advocate,
Filed
accepts
within 8
notice.
weeks result or they are pending file. Oh, what has happened? Have you filed your counter affidavit in this
In that case,
writ petition of 2020?
counter has not been filed.
Counter and result.
Recently, there is
No,
no
after-
IAG.
Yeah.
So if that is not filed, then how it can be disposed of? How your authority is telling like that? You are delaying the matter in spite of the order which was passed more than 3 years back. If you are not filing your counter affidavit, and on that ground you are rejecting the representation of the petitioner that one writ petition is pending in the High Court. Yes, it is pending, but it is pending for your fault because you have not filed the counter affidavit.
Within a week, I'll file two counters in both the writ petitions. Within a week, madam.
Look onto WPC number 26.
The representation was before the High Court. The representation was before the High Court, not before the government. This document. And the High Court has passed its order. Because it is pending, the High Court is not able to consider the representation. Because the
That is regarding
prayer in
petition.
the earlier writ petition is the same as is being prayed here.
Oh no, they should have filed the counter
Now,
affidavit.
government has not yet filed. No, in that case, they should have filed.
In
2020.
In 2020, we are
Ah,
telling, not that in this case.
In both the cases, we'll file it within a week, madam.
All right, WPC number 26049 of 2024. This writ petition has been filed by the petitioners so and so with a prayer they king let them. The London Council for the petitioner drew the attention of this court to Annexure 15, which is the earlier order dated 10/5/2023 passed by a division bench of this court in WPC number 19391 of 2009, in which All Orissa Judicial Employees Association was the petitioner and a similar relief was claimed. And this court disposed of the writ petition, directing the petitioner to make a phrase representation within a period of 15 days, highlighting the grievances as has been made in the said writ petition, so that the authority can consider the same and pass appropriate order in accordance with law. Considering the nature of work discharged by the petitioner and also taking into account the report furnished by the SETI Commission as well as the judgment rendered by the Honorable Apex Court. It is the contention of the Land Council for the petitioner that after passing of the said order dated 10/5/2023, the All Orissa Judicial Employees Association filed a press representation on 25/5/2023, filed Annexure 16. And in the
We have one query in this matter. The self-same association has filed the earlier writ petition and subsequently again the same
No,
petitioner is filing?
no, my lord. It is Baleswar unit has filed that.
Only one unit has
Yes,
filed
yes,
that,
yes.
the earlier one.
Yes.
in which prayer has been made to consider the matter sympathetically and for a direction to the Law Department of Government of Orissa to take appropriate action on the genuine grievances of the salarized omens of the state judiciary. The Land Council submits that via Annexure 17, the authority disposed of the representation wherein it is mentioned that similar matter in WPC number 6995 of 2020 bracket election to all Odisha Judicial Employees Association District Unit Baleshwar versus State of Odisha and others is sub judice before this court. Stop. On perusal of the order passed in WPC number 6995 for 2020, we find that on 8/11/2021, the Land and Additional Government Advocate accepted notice on behalf of the opposite parties, and 8 weeks time was granted to file the reply and reason thereto, if any, be filed, to be filed 4 weeks thereafter. So, the Land Council for the state submits that counter affidavit is yet to be filed in WPC number 6995 of 2020. However, he has made a statement before this court that what time you return?
It's within 10 days.
We are giving you 2 weeks time. Within 2 weeks, we will file counter affidavit not only in WPC number 6995 of 2020, but also in the present writ petition. Stop. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. Land Council for the state accepts notice on behalf of all the opposite parties. The matter be listed along with WPC number 6995 of 2020. Give it after 2 weeks. Counter affidavit we filed in the meantime, serving copy on the Land Council for the petitioners in both the writ petitions. Rejoinder, if any, be filed in the meantime. This matter so. Yes.
Yes. Highly obliged.
Item 6.
May I please the order on Rule 10 is rejected. Petitioner is the daughter of the present case LRC. Now the LA case has been disposed of between the brother by compromising. Petitioner is not CRL. LA case number.
No, you moved to the court and the court has passed an order. Basing on that, now the matter has been taken by the government.
Without sharing with the daughter, the brothers are compromising the matter and matter has been disposed of.
You have filed a written note of submission which was given to the Land Council for the state.
Now the LA case has been disposed of by the court below yours.
Already.
My lord. By the brother.
What do you want now?
So you have to now amend the prayer or what?
We are challenging the order on Rule 10 intervention application.
Yes.
Now the final case, LA case is the number of such and such is disposed.
So it is frustrated.
Now this matter has become infructuous.
Infructuous.
Yes. The Land Council for the petitioner submits that since the LA case number 16 of 2010 has already been disposed of by the Land Civil Judge Senior Division Sundargarh during the pendency of this writ petition has become infructuous.
The mutual compromise between the brother.
We
cannot say.
Dispose of the interim order challenge court finally se proceeding dispose of in view of such submission, this writ petition is disposed of as infructuous. Yes.
Item 7.
Then, my lord, the order under Annex 5 not releasing the compensation for structure and land was under challenge before the Honorable Court. Last occasion, your lordship directed me to produce the copy of the judgment. I have not been able to procure it.
Title suit.
Yes, ma'am. Your lordship allow me some more time to obtain the copy. I have applied for satisfaction.
Copy of the plaint and decree passed in title suit number
Yes, ma'am.
31.
Yes, ma'am. I have applied.
What further time you require?
My lord, I have applied for the
अरे
copy.
आपण
How much
କହିବେ
time
ନା,
you require?
କେତେ ସମୟ ଦରକାର ଆପଣ କହିବେ ନା
2 weeks time, your lordship.
ହଁ ସେଇଆ କୁହନ୍ତୁ. The learned and counsel for the petitioner takes for 2 weeks time to comply the order dated 2/12/2024. Leave this matter 2 weeks further.
Item 8.
Which, my lords, I was to obtain instructions on the status of the land. Despite about 3-4 communications not been done, my lord may kindly give me last chance. If not, then my lord may direct the authority itself to answer this way.
The case of the petition like this, earlier the petitioner approached with the Honorable Court that was disclosed at the.
You are still continuing there. Mr. Roy, you are still continuing in that place. ଆପଣ ସେ ଯୋଉ ଜାଗାରେ ବର୍ତ୍ତମାନ
Yes, yes.
ସେଇଆ ତ
I'm
କହିବେ ଆଉ କଣ ବୁଝିପାରୁନ
still continuing
Yes.
there and
all right, the learned counsel for the state seeks some more time to obtain inspection regarding the status of the land. ଗୋଟେ ସପ୍ତାହ ପରେ ରଖିବୁ.
My lord.
So please this matter in the week commencing from 20th of January 2020.
stay may be granted. They have taken so many time.
ଆପଣ ଯେବେଠୁ ରିଟ୍ ପିଟିସନ ଫାଇଲ କଲେଣି ତାପରେ 3ଟା ଡେଟ୍ ଗଲାଣି ଆଜି 4th ଡେଟ୍ ଆପଣ ଏପର୍ଯ୍ୟନ୍ତ କିଛି ଆପଣଙ୍କୁ ଆକ୍ସନ ନିଆଯାଇଛି କି
ନାଇଁ
ତାହେଲେ ଭୟ କାହିଁ କରୁଛନ୍ତି? Yes, next.
Item 9.
May I please, your lordship? Your lordship, this is the case of the All Odisha Judicial Employees Association seeking the benefits of heads of department. In the last occasion, your lordship directed to take instruction whether the recommendation of city commission has been implemented or not as per direction of this honorable court.
But I have not yet received the Register General of our own honorable court is to respond. Well, I'll communicate with him today itself and I'll obtain it.
All right, the land council for the state seeks some more time to obtain instruction in portions of the order dated 9/12/2020.
My lord.
So let it come on 27th,
My lord.
27th January 2025.
Item 10.
It's 10 I'm appearing for. If the opposite party will express some time may be granted to file. 3 weeks time.
For filing counter.
Counter activity.
Okay. Mr. Pranay Mahanti, Land Council, appearing for
All the opposite.
for all the opposite,
Hello.
for the opposite parties. How much time you said? 3 weeks.
3 weeks. My lord.
3 weeks time to file the counter affidavit. Please this man. 3 weeks for you to do that. No, like.
Item 11.
The land council for the petition is present.
May I please? Last occasion, my lord has directed to file legible copy. Accordingly, file a legible copy. I had answer 7, which is informed before the court in this petition. The petition earlier after is court.
Have you given that copy to also the land council for the state?
No.
ତାଙ୍କର ଦେଖିବାର ଅଧିକାର ନାହିଁ ନା କଣ? ଆପଣ ଯୋଉଟାକୁ ଚ୍ୟାଲେଞ୍ଜ କରୁଛନ୍ତି ସେଟା ଆମେ ପଢି ପାରିଲୁନି, ସେ କେମିତି ପଢିବେ? ତାକୁ ଦିଅନ୍ତୁ କପିଟେ। Okay, now what is your submission?
The petition earlier approached the court and that was disposed of by additional court.
Where is the earlier order?
I have quoted me.
Where have you quoted?
Page 10.
Page 13 of the writ petition.
Page 10.
Page 10 may be petition.
Page 10, okay.
Lord Counsel, with the petition states that the case of the petition is covered by the judgment of the appeals court in case of Mohammed Coalfield Limited versus another versus Matthew Suram reported. And in the above the court, without issuing notice to the opposite party, disclose the petition, direct the opposite party to consider the case of petition in the light of judgment of the appeals court in the Matthew Suram case.
Yeah, then what happened?
That is rejected by this, by the Mohammed Coalfield by the answer statement. Yes, 35. On the ground that
I see, Annex 7 जो legible copy टा कुछ कहाँ है इधर? अच्छा 8 है.
Yes, 36.
Operating 32.
36.
36.
It's not the legible copy. Which one is the legible copy?
Annex 7.
No, Annex 7, you have mentioned, it is mentioned to be legible copy, but it is the same copy. It's not legible at all.
He would have put and he would have put it. He was doing better.
Yes, that is the one. All right.
Operating portion
and whereas
36.
36.
Yeah.
And whereas.
And whereas the petitioner filed a petition for employment of her daughter, Mamata Singh and Honorable High Court passed the order and directed the opposite party to consider the case of petition in the light of the judgment passed by the Honorable Supreme Court in the Matthews CORAM. Matthews on case Honorable Supreme Court, India has directed to constitute the claim Commissioner for 14 villages, Sundargarh district. Just the Commissioner has prepared a report in Gopalpur Part 1 report where the court of date has been fixed on September 20th. This said report, Commissioner category stated that unmarried daughter below 30 years as on court of date is not eligible for employment. Then the daughter of petition is not eligible for employment. In Matthew's case, also. My assumption is that the president is an unmarried daughter. And he had to say, even if one of the brother got employment in 2018, and see, he is residing separately, not asking to the unmarried daughter who is a handicapped person. And that led petitioner, if not true, who filed application for appointment or RR policy. Now she is residing in the maternal uncle's house. And her the ancestral property has been lost, taken away by the Mahadi Coalfield. And the report and the decision, as per the Matthews report, age of the 31 will be amended in 2030. RR 13 million. My assumption that now she is residing separately and at the maternal uncle house. Now brother is not asking to her and she is eligible to get that post as she is separate unit, not a joint, separate unit. Separate unit has been decided by this case by the Mahadi Coalfield versus Matthews number, page 45. If unmarried daughter is residing separately, separate unit means.
Yeah.
Separate unit means the married or unmarried male. Now here is the case of unmarried daughter. She is residing separately from her family and a brother who got appointment or RR policy, she is residing separately. In that Matthews report, at least one person should get appointment or RR policy. At least one person. That I am highlighting people also that since the present petition unmarried, she is residing separately and she has or ancestral property has been taken away by the Mahadi Coalfield. And
what about this age factor?
Age factor 45 million. You know, 45 major.
Says that the commission has categorically stated that the unmarried daughter below the 30 years as the cut-off date is not eligible for the employment.
At present 31. I have given at present 31. I have given it.
So by the cut-off date, what was her age?
I will do again that is my question. Because
there
94 matter. In the meantime, so many things are 94 matter.
You take instruction.
You have to take instruction. Oh, that is the main factor.
Yes.
So how you have to substantiate that upon ठीक अच्छी upon writ petition लिख दी जाती तार age टा होची 30 years.
At present, but then 31 है I will give the certificate.
अपना लिखी दी जाती but since you have to substantiate that at that time your age was below 30. So for that you have to produce some document to prima facie to come to the conclusion that or the opinion that you are 30 years you are
At present 30 years. Yes, at the time of cut off date, whatever you need.
Cut off date रे आपनकर बयसटा 30 वर्षरू कम थिला ता पई डॉक्यूमेंटरी एविडेंस कोन देइछन हमें पचारछु पुरा आपनको.
First of all, I go to cut off date. He had applied the 2018. Now at 30 years. Now 2000 in 7 years.
So on the date of cut-off date, what was her age, and to substantiate the age,
yes,
only declaration is not there. Declaration substantiated by some
Cut-off.
documentary.
Yes,
I'm allowed.
because this what is the cut-off date in this case?
I am not.
The report is not with us even. This
94.
Justice A.K. Paricha report is also not.
That has been dealt. That doesn't deal in this case.
No,
That
very
dealt.
right. No, that has been dealt in part. No?
Annexure 5 रे page 33 रे आपनकर date of birth लेखा हिची in that school leaving
Certificate.
transfer certificate. It is mentioned that your date of birth is 9/6/1993.
93.
So if it is 9/3/1993, then you are filing this writ petition in the year 2024.
Prior to this, there is another resolution. Prior to this application, there is another resolution 23.
If this date is taken to be correct, then your you are now, is it about 31 years when you
31,
filed the writ petition?
31 years.
So then this copy which you have filed and placed before us, this legible copy of Annexure 7,
Yes.
right, which you just placed, wherein this Justice A.K. Paricha's commission report has been quoted therein. It is mentioned that where the cut-off date has been fixed on one. So in the state report, commission categorically states that unmarried daughter below 30 years, cut-off date is not eligible.
More than 30 years interpreted.
ତେଣୁ ସେପ୍ଟେମ୍ବର 2010 ଟାକୁ ଯଦି କଟ୍ ଅଫ୍ ଡେଟ୍ ବୋଲି ଧରାଯାଏ ଏବଂ ସେଇ ଡେଟ୍ ରେ ଯଦି ଆପଣ 30 ବର୍ଷ ରୁ କମ୍ ଅଛନ୍ତି ତାହେଲେ you are not eligible for the employment. ତେଣୁ obviously ଆପଣଙ୍କର ଡେଟ୍ ଅଫ୍ ବାର୍ଥ ଯଦି 1993 ହେଲା ତାହେଲେ 2010 ରେ ଆପଣଙ୍କ ବୟସ କେତେ ହବ? You are 17 years. So obviously, you are below 30 years, then you will not be eligible for employment. Bujiparle.
So that has been amended to 113. RR policy 16 has been amended to 113.
Now this report has come in 2010.
17.
17. So by then the amendment was already there.
That has dealt with. Still then I am examined because para 41 kindly see.
Para 41
judgment. The difference between the RR 26 and the policy was amended 113. Essentially, judgment.
Which judgment?
How much is concerned?
Where is it?
That I report 22.
No, what sort of
that I reported
judgment कौन सी साइटेशन कौन
that are
नहीं
dealt with in
आप
decision.
पाक को देवे ना अपन सीधा पढ़ दी चल जाइए
That are
कौन
decision.
को फैक्ट्री please place the matter properly it's not that
Sorry, that I reported 2022 year 2022.
ଆପଣ କମ ସେ କମ ସେଇ ଜିନିଷଟା ସବୁ କଜ ଲିଷ୍ଟ ର ଉପରେ ଲେଖା ହଉଛି ଯେ ଯଦି କୌଣସି ସାଇଟେସନ ବା କୌଣସି ଆକ୍ଟ ଯଦି ଆପଣ ରିଲାଏ କରିବାକୁ ଚାହୁଁଛନ୍ତି ପ୍ଲିଜ ଗିଭ୍ ଇଟ୍ ଇନ୍ ଆଡଭାନ୍ସ ଟୁ ଦି
Next week, absolutely. Next week, absolutely.
ସବୁ ଲିଷ୍ଟରେ ଲେଖା ହଉଛି କେମିତି ସେ ବାହାର କରିବ ଆପଣଙ୍କର ଲେଖନ୍ତୁ ଦି land council for the petitioner seeks for an adjournment next week list this matter on 13th January 2025 yes
Item 12.
Commissioners of the railway employees, my railway officers. This writ application was filed challenging the order under Annexure 1 at page 13. That is order dated 31st January 2024, passed in a contempt proceeding by the Learned Tribunal, Central Action Tribunal in CP number 31 by 2023. Here what happened, my lord? The opposite party was a land user and he has filed an original application in the year 2012. That is OA number 427 of 2012. And this was disposed of under Annexure 2, directing to consider his case in view of the judgment passed by this honorable court. Accordingly, there is delay in obeying the order passed by the tribunal. Subsequently, we have considered the case and passed order under Annexure 3, rejecting his prayer. Accordingly, though he has filed contempt application, but that was dropped since we have complied the order. And challenging that rejection of his prayer for consideration, my lord, he has filed another writ application before this honorable court, which was been dismissed. So Union of India also filed the writ application challenging the OA, my lord. And that writ application is still pending for adjudication. While the matter stood thus, he has filed another original application.
why the Union of India filed the OA
because these are the railway officers. Earlier Union of India, since contempt application was filed against the officer for which they have filed this present writ application. In person, the contempt application was filed. Earlier against the Union of India, against the Railway Department, the original application was filed. Original application was directed to consider his case in view of the judgment passed by this honorable court in different cases, my lord. We have considered. Accordingly, his contempt application was dropped.
okay you said that then you said that a fresh writ petition was filed that was also dismissed
when the contempt application is dropped, he has filed a writ application that was dismissed by this honorable court.
Right.
But we have also filed a writ application challenging the original order in OA order, my lord. Where his case has been directed to be considered. That is still pending since 2015.
But that has become infructuous because by virtue of that order, you have already rejected his claim. So that writ petition has become infructuous.
That writ application was disposed of.
Okay.
Subsequently, we have stated that no, this case is not applicable. That order was recalled and the application is pending. In the meanwhile, what has happened, my lord? He has filed another original application. And in another original application, also the tribunal has directed to reconsider his case. And we have also disposed of his prayer under Annexure, my lord, 7 at page 70. 70, my lord. Under Annexure 10. That
not
is speaking.
Annexure 7.
No, not 7.
That is Annexure 10 for if it is order dated
18/7/23.
My lord.
That is Annexure 10.
Annexure 10. So
Annexure 10, we have disposed of his original application, rejecting again, citing all the reasons. That is, lordship kindly have a glance to page 70. Order dated 18/7/2000.
Yes.
This detailed order was passed, my lord.
Then why contempt was filed?
In spite of that, he has filed a contempt application.
When contempt was filed?
Challenging this rejection order, my lord. Instead of filing original application, he has again filed a contempt application, and the Learned Tribunal asked.
Let us see this contempt application prayer.
The lordship kindly see.
At page?
Page, my lord. Contempt application, my lord. I have Annexure 7, my lord.
Prayer, my lord. Page 55. It is therefore prayed that the son of
To comply the order dated 15/3/2023.
23. Though we have complied. That has been complied under annexure 10. So he has to file another original application.
Right.
But instead of filing another original, this
So now
application has been
that has been entertained and this
order was passed under annexure 1.
annexure 1 कौन सी file है?
Again reconsider. Your Lordship kindly see paragraph number 8 onwards at page 21. We have considered the rival submission of the respective parties and perused the records on microscopic examination of the order of this tribunal dated 15/3/2023 in OA number such and such, vis-a-vis the order of the rejection dated 18/7/2023. So that is within the knowledge of the tribunal. This tribunal is well convinced that the order of rejection is not sustainable in the eye of law because the ground upon which the grievance of the applicant is rejected.
It's all right, Mr. Gupta. When this contempt petition was taken off on this order, it seems that it was reserved on 17/1/2024, and you were given an opportunity of hearing also because your names also finds place. But Central Government Council is there. So why didn't you point out that the prayer is totally misconceived because the order has already been passed in compliance of the order dated
We have that has been reflected page 8, page 21, paragraph number 8. On microscopic examination order of this tribunal dated 15/3/2003 OA number vis-a-vis the order dated 18/7/2023, which was the rejection order.
The tribunal is concerned rejection is not sustainable in the eyes of law because the grounds on which
as if they have entered another original application and passed this contempt.
So this was passed in CP means contempt petition. Oh, all right. This petition has been filed by the petitioners. Were all the officers of the railways, no?
My railways.
Were the officers of East Coast Railway?
My lord.
Okay. Challenging the order dated 31/1/2024 passed by the London Central Administrative Tribunal Cuttack Bench in CP number, CP bracket is civil number 31 of 2023. Order dated 31/1/2024 in so on. In allowing the CP and giving an opportunity to the chief personnel officer to consider the case of the petitioners in the light of consideration and appointment provided to Sri Krishna Chandra Nayak, Sri Satyavrata Nayak, Sri Gati Iswara Denga, in compliance of the order of this court, which was upheld by the Honorable Supreme Court, notwithstanding the fact that the applicant is the grandson of the land lawyer, and further to communicate the result thereof within 2 months from the date of receipt of the copy of the order. It is the contention of the Land Council for the petitioners that the aforesaid CP bracket is civil number 31 of 2023 was filed on 1/8/2023 by one Gautam Behera, comma, bracket लिख दूं तो opposite party in this writ petition with a prayer for a direction to the respondent oblique opposite party authorities to comply with the order of the Honorable Tribunal dated 15/3/2023. The learned counsel for the petitioner submitted that 15/3/2023 passed in OA number 15 of 2022. The learned counsel for the petitioner submitted that in compliance of the order dated 15/3/2023 passed in OA number 15 of 2020, Principal Chief Personnel Officer had passed the order dated 18/7/2023 in rejecting the claim of the appointment of the opposite party in railways. It is further contention that against the said rejection order dated 18/7/2023 under Annexure 10, the opposite party should have filed an original application if is aggrieved by the said order, which he has not done. Instead, file a contempt application, which is not maintainable at all, in as much as by the time the contempt application was filed on 1/8/2023, the order under Annexure 10 has already been passed on 18/7/2023. Therefore, the impugned order dated 31/1/2024 under Annexure 1 passed in CP bracket is civil number 31 of 2023 is not sustainable in the eye of law. Issue notice on the question of admission indicating to the opposite party, indicating that the matter shall be disposed of at the stage of admission. Requisites for issuance of notice on the sole opposite party be filed within a week. Matter be placed after 4 weeks. Counter, if any, be filed in the meantime by the opposite party. Stop. IN number so and so. There shall be stay of operation of the order dated 31/1/2024 under Annexure 1 passed by the London Central Administrative Tribunal in CP bracket with civil number 31 of 2023 until further orders.
Item 13.
Lord, in item 13, my lord, I beg to appear on behalf of the petitioner. My lord, if your lordship has the order passed on 2nd of December 2024 in this matter, my lord. It's a speaking order, my lord. If your lordship has a look at that, 2nd December 2024.
is what happened, Land Council, about those two
Yes,
review
my lord. So, my
petitions?
lord, we have written to the registry, my lord. In fact, we filed and served a copy of the affidavit. We sent a letter to the registry to list the review petitions, my lord. As yet, they have not been listed, but we have already written to the registry of the Supreme Court to list the review petitions, my lord. What has
What is
happened
your instruction, Land Council for the state? Have you gone through the order dated 2/12/2024?
Yes.
You have not gone through. So this matter is to be adjourned to some other date so that it
Yes,
will
my
be
lord.
listed.
Yes, my lord. That's right, my lord. Actually,
Also,
state was to correct,
what
my
would
lord.
be the, is it possible, would be convenient if it is listed in the month of February 2025?
Yes, my lord. That should be all right, my lord. And I hope the state will not precipitate the matter, my lord. Your lordships have indicated, my lord, orally to the state not to precipitate the matter because we are taking steps. We
Please go through
don't
that
want any
order
reversal.
and the submission which has been made by the London Senior Advocate. And we are listing it on 10th February.
Very well, my lord. Very well.
Mr. Dhruv Mehta, London Senior Advocate, appearing for the petitioner, Anil Agrawal Foundation, submits that steps have already been taken before the Honorable Supreme Court for early listing of the review petitions, and the matter may be taken up after 4 weeks. And it apprise this court about the status of those proceedings, the proceedings in those two review petitions. Land Council for the state also seeks for adjournment to obtain the status of the proceeding, put up this matter on 10th of February 2025.
Lord, may I only request, my lord, like last time, your lordship may orally indicate to the state not to precipitate, my lord, and act upon those letters. We don't want an irreversible situation. That's all, my lord.
Yes, yes, that of course, there. Yes.
Yes, so state council maybe, my lord, may make a note of that.
The matter is in a review petition. It says that since it is sub judice and that steps following that action should not be taken till next day. We have not passed any order, but that was the instruction given.
I understand. My lord, one full submission is this, that this writ was lost here. Petitioners, then Supreme Court, they've already lost.
Right.
Now there is a review. So
Right.
unless notice is issued in the review petition, the state will not do
No,
anything as such.
that is the exact submission which
Ma'am.
has been made, that they are taking steps for early listing, and the this review petitions numbers are also of 2023. That so we are giving the last chance so that they will take steps.
My only submission that the instructions will be from their side, because unless notice is issued in the review petitions, I will not be able to.
Obviously.
I'll instruct my officers, my lord, not to.
Okay. All right.
Grateful, my lord.
Item 14.
Petitioner is displaced person, so he'll have to then project matter. And his entire landed property will be acquired by the government. Therefore, my lord.
Your representation annexure 3.
Yes, my lord. I have allotted 2 acres of land.
When you submitted that representation?
Several representations have been signed, my lord.
The last one was on 20th of November.
2011-2024. To file this related application, my lord, this representation is valid. From the date of possession, he has sent a representation, my lord, but he has not kept the receipt.
Mr. Counsel, just have patience. Your representation is dated 2011-2024, but it has been sent by registered post or speed post, whatever it may be, on 21/11/2024.
Yes, ma'am. Yes,
which
ma'am.
appears on page number 13.
Yes, ma'am.
So after that, you have not received any communication
from
the collector Sambalpur.
No.
All right, dispose of the representation. Annexure 3 is the representation, and it is to be disposed of like on their order. Yes.
Item 15.
May I please, your lordship?
Annexure 1, your lordship, was issued, which I never received. In 2007, I got it through RTI, your lordship. The allotment was made with regards to a land that is 65 into 90 feet, 65 feet into 90 feet, way back in 2000. That is at Annexure 2 is the allotment letter. Annexure 2 is the, sorry, my lord. Yes, Annexure 1 is the allotment letter at page 15. Annexure 2 is the intimation. These two documents I never received, for which I could not pay. Ultimately, after coming to know about the allotment for similar persons, I approached them through RTI, and on 19th October 2007, I received, my lord, all this information through RTI. That is
no, Mr. Sarangi, you are now challenging the
rejection order,
cancellation of allotment. That is your exact prayer in.
And your lordship directed earlier in 2023 to consider my application because they took a stand that the Supreme Court judgment.
No, where is the earlier order? First, let us go.
Earlier order, your lordship. Let us go, your lordship, to page 35.
35.
Annexure 10.
Sir.
Yeah.
Annexure 10, my lord. The matter is taken up through hybrid mode, heard such and such. The petitioner has filed this writ petition seeking direction to the opposite parties to reallot the land earlier allotted to the petitioner by Annexure 1 as per the terms and conditions stipulated in the order by Annexure 4, and on receipt of the premium to execute the lease deed.
Please come to paragraph number 6.
6. Having heard learned counsel for the parties and after going through the records, this court is not inclined to delve into the above disputed question of fact as to whether the petitioner has been communicated with the letter, as to whether the same has been issued by registered post or with AD or not. That apart, such dispute will not resolve the claim made by the petitioner in the present petition. Fact remains, the allotment made in favor of the petitioner is not being disputed by either of the parties, and as such, the land is still available. In view of such position, let the case of the petitioner be reconsidered, taking into account the order dated 19/11/2013 issued by the government of Orissa Jal Resources Department. To that extent, let the petitioner approach the competent authority for reconsideration of the same within a period of 15 days. Hence, so that the same can be considered and disposed of within a period of 2 months by giving opportunity of hearing to the petitioner. Needless to say, so far the applicability of the judgment of Apex Court Maruti Vishwal is concerned, the GA Department order dated 19/11/2023 to 13 was not brought to the notice of the Apex Court, and as such, the order dated 19/11/2013 has not been dealt with in the said decision. Therefore, the said decision is distinguishable. Thus, it is open to the government to take a decision on the grievance made by the petitioner within the time stipulated in terms of the order dated 19/11/13. Pursuant to this, my lord, this present order Annexure 11 has been passed, which I am seeking, challenging before your lordship.
Which order was passed?
Annexure 11.
11. This Annexure 11, page 38, 39 is the operating portion. They say this comes under a different scheme after 30 years. Never they have stated that either in any of the litigations, my lord, and that they say that this is not condemnable because payment was not made within 75 days.
So what can be done?
Whereas the scheme covers, which your lordship has referred to in that is at, my lord, my case covers at page 19, paragraph 2. This was universally made applicable on 19/11/2013. Should I place that, your lordship?
So the reason has been assigned in that impugned order dated 12/3/2024.
My lord.
Right.
My lord.
So where is the fault, or what is the you say that illegality committed by this authority while disposing of your representation?
Your lordship, the 2 points here.
Yes.
They say my application was on a different scheme. This is the first time they are saying that my application was a different scheme of 89, though I had applied ever since 2089, your lordship, 90. One scheme is there. That is one part which is to be looked into by your lordship. The second part is on perusal of records is in that paragraph 4 of the allotment letter.
Please come to paragraph page number 40.
40.
40 ro pratham place karo.
Order dated 19.
No. Page number 40. 40. Jota apanଙ୍କର impugned order ta jota.
हाँ sir. And where is?
Head pardon.
The department order dated 19/11/13 pointed out only the Honorable High Court in the aforesaid order dated 22/2023 only governs the Kalinganagar plotted scheme relating to Mauja Ghatkia plotted in the year 1989, and hence the same cannot have any applicability over allotment of plot under any schemes area of the capital city other than the Kalinganagar plotted scheme.
Yes.
Here my answer is your lordship has. Sir, the instant case relates to allotment of plot number such and such and does not relate to allotment of plot under Kalinganagar plotted scheme plotted in the year 89. Regularization of such allotment is not possible under the department order dated 1911-2013. Third, on perusal of record, it is seen that the paragraph 4 of the allotment order dated such and such categorically stipulates that the allotment order will stand automatically cancelled if the prescribed premium is not paid within 75 days from the date of receipt of the allotment order. The allotment order stands automatically cancelled for non-payment of the premium within the prescribed period. Therefore, the prayer for the petition reallotment is being devoid of validity is rejected.
So, are you disputing what has been stated here that the relief which you are seeking for that is applicable for that a particular scheme which was floated for that Kalinganagar, but here you are trying to implement, asking the authorities to implement it in case of Chandra Shekhar.
My application was there. The allotment was made in Chandra Shekhar. That is part one, your lordship. This is the first time because there are several writ petitions. First time they are disclosing. Even there is a counter affidavit in the earlier writ petition. There also they have not.
For Chandra Shekhar, there may be another scheme also, altogether different scheme.
That they have not disclosed in the counter affidavit. And this aspect, my lord, that was there. The counter affidavit was filed.
If a particular area, if scheme is floated, that may not be applicable to the other area, like Kalinganagar scheme may be different than, so it cannot be.
Your lordship would be right. Your lordship would be right.
So therefore, you are to place before us that what was the scheme of that Chandra Shekhar in which you are seeking for relief and how you fulfill the criteria in spite of that.
Yes, your lordship. What I am my submission to that, your lordship, in WPC 18,698 of 2016, they are the earlier disposed. It is for 22/9/2023. They have filed a counter affidavit. They are not disclosing all these things. There, my case was this only. They are saying the Malati Devi case is covered, hence it is not considered.
No. Let us say what they have not stated, stated. We are now on a very particular point that you want your allotment is in respect of Mauja Chandra Shekhar or not. Let us be clear.
Record says so, but how can I say no now?
So if that is there, then if a particular scheme is there.
Whether Annexure 4 is applicable or there is some other scheme. Your lordship. May I pray your lordship to call for this next week along with WPC 18698 of 2016.
ଆପଣ ଏତିକି ବୁଝୁନାହାନ୍ତି କାହିଁକି ଚନ୍ଦ୍ରଶେଖରପୁର ପାଇଁ କୌଣସି ଯଦି ସ୍କିମ୍ ଫ୍ଲୋଟେଡ୍ ହେଇଛି ତାହେଲେ ତାର ଟର୍ମସ୍ ଆଣ୍ଡ କଣ୍ଡିସନ କ'ଣ ଥିଲା, କେତେ ଦିନ ଭିତରେ ପ୍ରିମିୟମ ଦବାର ଅଛି ଯାହା ନାଁରେ ଆଲଟମେଣ୍ଟ ହେଇଛି, ଯଦି ଆପଣ ପ୍ରିମିୟମ ନ ଦେଇଥିବେ ତାହେଲେ ନିଶ୍ଚୟ ପ୍ରୋଭିଜନ ତା ଦେହରେ
ସାର୍ ଏ କେସ୍ ଗୁଡ଼ା ସବୁ କାହିଁ ହେଲା, ଚିଠି ଗଲା ବୋଲି କହୁଛନ୍ତି କି we have not received. Those are the cases. No, those that this circular has dealt.
ଏଥିପାଇଁ ତ ସେଥିରେ ଫ୍ୟାକ୍ଚୁଆଲ ଆସ୍ପେକ୍ଟରେ ଆଗରୁ
ସେଟା ତ ଆପଣ କହିଲେ ଆମେ ଯିବୁ ପସିବୁନି ସେଠି
obviously
possible କାହିଁକି ୟା ଉପରେ just before a lordship we part with the case, my lord, for cases where land premium, it is page 19, for cases where land it is जो circular टा depend माने ये ହେଇଛି refer ହେଇଛି, for cases where land premium has not been deposited by the allottee on the ground that allotment order sent to them have returned due to non-service of their present address and the allottees are coming with a prayer to issue fresh allotment order. Allotment order shall be issued immediately to the allottee in their permanent address with a direction to deposit the amount. A clause टाको cover କରୁଛି all these cases.
ଆପଣ ଯେତେବେଳେ
ମୁଁ ସାର୍ ସେ counter affidavit file କରିଦିଏ, your lordship will be satisfied what I am talking about.
No, ଆପଣଙ୍କୁ ଏଟା ଜେନେରାଲ ଜିନିଷ ହଉଛି ଯୋଟେ ଗୋଟେ ପର୍ଟିକୁଲାର ଆପଣ ଆପ୍ଲାଏ କଲେ ଆପଣଙ୍କୁ ସେ ଆଲଟ୍ କରାଗଲା ମାନେ ତା ଦେହରେ ନିଶ୍ଚୟ ପ୍ରିମିୟମ ଫିକ୍ସ ଅପ୍ ହେଇଥିବ, ଆପଣଙ୍କୁ ଏବେ ଏଇଟା ଦବାକୁ ପଡିବ, ଏଇ ଆମାଉଣ୍ଟ ଦବାକୁ obviously you have defaulted.
ନାଇଁ ସାର୍ ସେଟା ପରେ ମୁଁ ପାଇନି ଚିଠି,
पाई ना दी जे आपण डिफॉल्ट न कले से तो आपण को अलॉट
हाँ,
कर दी थांते ला
पाई कि न पाई,
it presupposes that you have
Defaulted.
in depositing the premium amount, but that scheme also requires that if somebody defaults in making the premium amount, then obviously a notice is to be issued and he will be given an opportunity to make that payment of that premium. They say that notice has been issued. You say that you have not received the notice. The matter lies there. But we want to see that where is that scheme?
For Chandra Shekhar.
Yes.
In this connection, may I pray your lordship to call for the earlier record? Counter affidavit thila sekre.
Next to page 16 also clear that. Page 16.
That is the allotment letter, which is received in
To say
30
that on the basis of the lottery drawn in March such and such, the drawing plot number such and such, measuring such and such, is the residential purpose at the allotment letter bearing number such and such has been sent to you by registered post with AD in your village address, that is such and such. In the said allotment order, you are requested to deposit the premium rupees such and such.
Court ko dile.
From date of the receipt of this order.
সেই টঙ্কা পর দেই না সে আমি কুহাউছি কাম
Yes, sir. 18,698 of 2016.
तो 2000 ମସିହାରେ ଯୋଉ ଜମିର ମୂଲ୍ୟ ପାଇଁ ଆପଣଙ୍କୁ କୁହାଯାଇଥିଲା ପ୍ରିମିୟମ ଡିପୋଜିଟ କରିବାକୁ 32,232 ଟଙ୍କା ବର୍ତ୍ତମାନ ଆପଣ ତ କମ୍ପ୍ଲାଏ କଲେନି ବର୍ତ୍ତମାନ ଷ୍ଟେଟ ଯଦି
ଭ୍ୟାଲୁଏସନ କରିଛନ୍ତି ଏବେ 2.5 କୋଟି ତା ଭ୍ୟାଲୁଏସନ ଏବେ କରିଛନ୍ତି 2.5 କୋଟି ମୁଁ ପେମେଣ୍ଟ କରି ବୋଲି ଅଣ୍ଡରଟେକିଂ ମଧ୍ୟ ଦେଇଛି ଲାଷ୍ଟ ଥର ଲର୍ଡସିପ ଡାଇରେକ୍ଟେଡ ମି ଟୁ ଫାଇଲ ଏନ୍ ଏଫିଡେଭିଟ
2025 ରେ 32,000 ଟଙ୍କା 232 ଟଙ୍କାରେ କେମିତି ପାଇବେ
ନାଇଁ ସାର୍ ଏବେ 2.5 କୋଟି ଟଙ୍କା ଭ୍ୟାଲୁଏସନ ହେଇଛି
You are ready to deposit at the present rate.
हाँ मुझ page 32 ने देइछि उडे affidavit pursuant to your lordship direction. I am the about direction देइथिले to file an affidavit.
Annexure 9.
Annexure 9 your lordship.
ଜମି available ଅଛି ନା ନାହିଁ
ଅଛି ପରା sir personal appearance ହେଇଥିଲା ତାରେ କୋର୍ଟ ମଧ୍ୟ କହିଛନ୍ତି ଏଥିରେ এই order ରେ ଆପଣ କହିଛନ୍ତି
by the way ଶୁଣନ୍ତୁ Mr. So we will definitely adjourn, give him time to, but you just take into account two things. One is that whether that particular piece of land is available or not, and what is the rate which you want him to deposit. If he is ready and willing to deposit, why it cannot be allotted to him? Because it was earlier allotted, whether he has received the deposited the premium or not. At that time, it was 32,000. Suppose now you have fixed the rate to 2 crores and some odd, and this man is ready and willing to deposit. So why it cannot be allotted to him? So that instruction also you receive.
Apno sir finding अछि the land is still available.
No, it's all previous.
Sir page 36 रे the personal appearance ହେଇଥିଲା actually ତାଙ୍କର ସେ କହିଥିଲେ ନା stay ଅଛି ଟେ ଚାଲି ଅଛି
এটা order agru pass this writ petition has been filed by the petitioner Vijay Kumar Moiti challenging the action of the opposite party in cancelling the allotment in favor of the petitioner, and for a further direction to allot the scheduled lands in favor of the petitioner on receipt of the applicable premium/price. The land counsel for the petitioner, senior advocate, drew the attention of this court to the earlier order passed by this court in WPC number 18698 of 2016, which was disposed of on 22/9/2023, wherein this court observed you paragraph 6 operative portion of legislation. The land counsel for the petitioner submits that after passing of the order, the by this court. The director of estate and ex officio so and so, opposite party number so and so, has rejected the prayer of the petitioner for reallotment of the land. So also the representation. And the ground stated therein. The it appears that on 27/6/2000, the petitioner was allotted the land in question, that is plot number 298, measuring an area of 65.2 into 90 annexure 2A in DRG so and so in Moja on the, and he was asked to deposit the premium of rupees 32,232 within a period of 60 days. And in that connection, annexure 2 dated so and so was issued. Land counsel for the petitioner, senior advocate, fairly submits that the said premium amount was not deposited by the petitioner, as no such letter under annexure 2 has been received by the petitioner. However, he submits that since the aforesaid lot is still available to be allotted and the petitioner is ready and willing to deposit the premium amount for such land, for the land. Let the land counsel for the state obtain instruction regarding the availability of the plot in question. So also the price that is to be paid by the petitioner for the purpose of allotment. Matter be listed in the week commencing from 20 तारीख रखी हबो जमीटा अछि ना नहीं केते पैसा ते ती बुझिबे on 20th of January 2025. List this matter along with who number सहित आछियो कोन
20,000 sorry 18,698 2016
WPC number
18,690
98 sir.
All right.
Sir, जो availability of the land कथा अपन finding देइ छथि अछि बेली
अबिकाटी बुझन तो से कोन एटा एते जिंस बुझिबे एटा बुझि देले कोन असुविधा
नाही नाही असुविधा किछि ना we need the land.
Yes.
Item 16.
May please, Your Lordship. But a notification for acquisition of a land made is published by the Tahsildar from Land Acquisition Officer Bharatmala Project Puri Manor under Annexure 1, page 11. In Ocean Council, page 15, I am concerned with this land. That is my page 15. Serial number 577.
So you have made a application under annexure 6 for payment of compensation.
So also 7, Your Lordship.
And 7 and objection 2.
Madam.
So objection to what?
But only objection, my lord, they are now land acquisition officer is trying to, my lord, disburse the money in favor of Rabindra Jena in private opposite party.
So the authority is to dispose of your objection.
Yes. My lord,
Annexure 7.
No, just let us be clear. Whether you want disposal of your application under annexure 6 or your objection dated 10/5/2023, be clear. कौन अपन चाहूँ चंदू?
Disbursement no. Then you will also take cognizance about the matter to issue notice and no disbursement, then
No. He has not
Yes,
at
disposed
all
of.
disposed of. Neither he has considered your application nor your objection. So let both of them be disposed of within a
Yes.
stipulated time, okay?
Then my notice.
Now, we do not know whether it has been made or not, but
If you may say that
annexure
if it is
6,
not discovered, it may not be discovered. My instruction is not discovered.
annexure 6, so also annexure 7, है are to be disposed of within such and such time. जो हमें दो from the date of production of the certified copy of the order, in accordance with law, after hearing the parties' complaint, and the result thereof to be communicated. Yes, and it is made clear that we have not expressed any opinion on this one. No, we do not know what is there, and yes.
No, you will be given opportunity of being heard along with this while
Yes.
disposing the objection.
Next.
But my point is, they are trying to disperse the amendment for that reason.
Yes, next case.
Item 17.
Yeah.
This is not item application under section 753 method. Before the land acquisition officer for redetermining the compensation amount as per the judgment of the authority. That application is still pending.
Which is the application?
And that is annexure 3 method.
Annexure 3 series is the good application.
That is
Who the particular kuhantu?
28, the first one.
Acha. That is addressed to whom?
No, opposite party.
Opposite party kuhantu?
One.
Sole opposite party.
Sole opposite party. Annexure 3 series of the first application page number 28 that is to be disposed of by the opposite party, sole opposite party. Date be de 7/7/2023 is the date of that application. But usual order of 3 months. Yes.
Item 18.
May I please, my lord, on behalf of Mr. Mahanti, my lord, writ petition, copy of writ petition may be supplied to obtain instruction from the authority, my lord.
Cases like this, for the first time, this is from.
You are appealing for whom?
I am on behalf of Mr. Mahanti, Umesh Chandra Mahanti.
No, opposite party?
One.
Wait.
NHI.
My lord.
National Highway Authority, that is opposite party number
1, my lord.
Union of India represented through its secretary.
Transport and Highway.
Copy of writ petition may be supplied to after.
We just want to know that Union of India, usually Mr. Padhita Achanti.
Yes, ma'am.
Okay. So, have you not served a copy of the writ petition?
My lord, I have served the copy to Union of
Union of
India.
India, yes.
They are appealing for the Union of India. Say that they have not received the copy. नहीं आपण ठीक अछि स्टेट को एवं ये को आपण जेतले पक्के इन एडवांस आपण को कॉपी ओटे दबाउ पड़िबो स्टेट को आपण बदे कॉपी देई छंदी मिस्टर you have received the copy of the writ petition.
Yes, I have.
So you have to serve the copy. All right. आपण कॉपी टे दियंतु पहर दिन आसीओ मैटर टा अजी की कोन लेखन the submission is made on behalf of the Union of India, Mr. Padi and so and so. Umesh Chandra Mahanti to? Central Government Council.
No, he's the national highway. He's acting for the national highway.
Transport and highway.
The Union of India is separate and national highway authority. He's acting for the national highway authority.
But they have not been made a separate party. Union of India represented through secretary.
They made a party. But the page 26, that is the Jatiya Rajapatha Ain Sajan. Which has been issued.
Opposite party. Whole thing so Union of India पे हमें जाने अच्छी opposite party. तो कहाँ को देबे इटा को?
Umesh Chandra Mahanti.
NHI is not a party, madam. NHI is not a party. Union of India represented through Secretary Ministry of Transport and Highway, where Mr.
Transport and Highway.
DSGI will be there.
Yes, my lord. Union of India represent through Ministry of Road and Transport Highway.
Yes.
So for that, Mr. Pari is to
Party is to.
Yes,
appear.
Lana DSG has to appear for that.
So why will copy will be served on you?
My lord, on behalf of Mr. Mahanti, I submit before this court because
You are
I,
making a submission, it's all right.
my lord,
Question is that if the opposite party number one is the Union of India,
my lord,
represented through the Secretary, Ministry of Road, Transport, Highways, and Mr. Pari says that he is to represent that opposite party number one.
my lord.
Why the copy will be served on Mr. Umesh Chandra Mahanti? Tell us.
Because my lord, in this writ petition, my on Mr. Mahanti, Umesh Chandra Mahanti name is reflected. That's
Why it is
why.
reflected? Why? Who has reflected it? He has filed the petition. Notice has not been issued. Why the name has been reflected? You have filed your Vinama.
Might have sometimes when the road transport is a party, the NH also party. They are appearing for NH, that's why might have it is happened. And system will explain put to properly.
Not a party.
Sometimes
You have filed
transport
your,
ଥିଲେ ସେଥିରେ
in
NH
advance
ପକ୍ଷ
you
ଥାଏ
have
ସେମାନେ
filed your
appear କରନ୍ତି
Vinama.
ସେଥିପାଇଁ କହୁଥିବି ଆଉ.
So we are asking this Mr. Pari to you just hand over the copy. to
Pass
Mr.
of
Pari.
this matter, my lord, whenever the Mr. Mahanti is here before this court, then please submit.
His name will not be deleted. It will just come day after tomorrow. All right. The name will remain there. We just wanted to know that why the name has been because the case has
NH
not
is
been.
not party.
A copy and counsel must be Deputy Solicitor General of India. By tomorrow you serve. Okay. And this matter will be taken off on 8th of January 2020. Right? Oh.
Much obliged.
Item 19.
Great reasons. Well, the petitioner is a petitioner for land use of the opposite part number one. A case was filed by the annexure one manor for to nominate him as to get an employment under the MCA. Annexure two manor running to the purpose of the brief class question directed to give upon employment in favor of petitioner number one man. Petitioner number two is the son. Petitioner number one is the father man.
No,
So,
you are challenging annexure 4.
Annexure 4 matters.
Right.
Matters.
So
By virtue of order of this honorable court, this has been passed by the authorities. Custody of the representations has been passed.
So what was your representation?
Representation is followed to give employment to my son instead of you.
Okay.
Father, instead of
What they
father.
have held?
They held that you are not eligible. But clause 8 of their policy manual, will found at annexure 5, the relevance is followed. Annexure 28. So page para 28, let's see, page 28 of the
Page
28 of the brief.
28 of the brief.
Minus.
Okay.
It starts from page 23. The annexure 5, Revenue Department, Orissa Settlement and Rehabilitation.
28 ଟା କୁହନ୍ତୁ ଆପଣ rehabilitation assistance ଲେଖା ହେଇଛି ସେଠି।
Minus. Type 1, let's see, type 1 industrial projects. The wording is employment manner. Families shall be eligible for employment by the project causing displacement of all agricultural land for the purpose of employment. Each original family will nominate one member of such family. However, the families are mentioned at para 2, F, I, V, or V will not be considered separately for employment. Any of one of among these categories may subject to eligibility.
So you mean to say that you come under this
My humble
type
sense.
A industrial
Fine.
project. In spite of that, the authority have turned down. So Harry, let us see that order, the impugned order, which you are pressing annexure 4. The reason that has been given. What is the reason given?
Reason they have cited the upon causing the.
They must have stated that you are not coming within that particular scheme or policy which you are showing to us at page 28.
Para 9, page 21. Page 21, para 9 of the rejection letter.
Yeah.
However, during the processing of the employment file of Chandra Shekhar particular the petition number 2 I'm claiming, it's found that during document verification, Chandra Shekhar Patri was below 8 years of age as on the cut-off date of that is 5/9/2010. And we have cited one of the judgment of the Honorable Appellate Court matter passed in SLP number 6933/2007, saying that it is not applicable.
You have two sons.
I have two sons.
One of your son has already been
Cut up.
employed
Cut up.
because he was more than 18 years.
4 years and he got qualified matter not as a land honesty in complete examinations come out successful.
Okay. But so far as this Ajayapati is concerned, if the cut-off date you are not that is the requirement is that as on the cut-off date you should have 18 years or above. But if you are found to be below 18 years of age,
That is 2010 man, I have some research.
yeah,
But you know, it's by the order dated annex order under annex 2 part by the claim commission madam. It is passed on 15/9/2022. Saying that mine is applicable means the father. But I want to nominate my son now. That is the question to be considered by madams. Based 14 National Guidelines Annex 2. In view of the same prayer, Mr. Kanurgol and the council agreeing for themselves submits that the petitioner has awarded monetary compensation leave of employment. Now he wants to employment. He has no objection for the same. For petitioner number 1, they have no objection. My father. But for the son, though I am nominating him to be appointed, they reject. I am also.
all right, you wanted your son to be taken on the employment in view of that monetary compensation. But fact remains that if the cut-off date is fixed, then that is applicable not only for your father but also for you. You means the son. So if on the cut-off that your son has not attended 18 years of age, how he will get the service? Even if you as a father wants it.
Curiously, but that the clause 8 that I have shown to my lords is not stipulated raised rated analysis. The reevaluation policy mark.
There is nothing about this cut-off date, age, nothing, Kishinai.
No.
No, then how can you supersede the order of the Supreme Court now?
Supreme Court, my lord, their judgment was applicable to me.
Yes, that is for all.
It is not applicable to me.
Oh, you say that judgment is not applicable to you. On what basis?
Because my lord, my assumption is that the son.
No, son is different. It's a complete policy. Under the policy, this decision has been taken.
That as on the cut-off date, what is the date?
Yes.
The London Claim Commission also, my lord, held that I am eligible. If I am eligible, my lord, denies supplement, I am nominated.
It is not, they don't say that you are not eligible. You are eligible. As father, you are eligible. That is not in dispute. The dispute is only when you want your son to be there in your place. So that is now subject to.
My lord, that is subject matter of this case, my lord. But my lord, para 8 of that nomination policy speaks, I can nominate.
No, you
nominate
nominate provided that
he fulfills the other criteria.
criteria.
That means the cut-off date, the nomination which you have, the person to whom you are nominating, he must fulfill the criteria that as on the cut-off date, his age should be above 18. Then you can nominate a person. There is no problem in that. So that is not satisfied in your case because your son was below 18 years of age as on that cutoff date. You can nominate, there is no problem. So you are also eligible, there is no, but the problem lies is that because of the Honorable Supreme Court decision, when the cutoff date has been fixed and a particular age has been set, if your son would have fulfilled that criteria, then your nomination would have definitely, if they would not have complied, then or accepted, then matter is different. But you are not disputing that your son was by then 18 years of age. Are you? Is it your case?
Can this policy decision be challenged at this stage?
But so far, my lord, the emotion is the clause 8 of that policy says it's not specified part of that.
But then that is already superseded by this decision. That is not under challenge in any manner.
The petitioner. Right, after arguing for some time, the land and counsel for the petitioner seeks for an adjournment to obtain certain specific instruction in the matter. Put up this matter on such and such adjournment. Yes, next.
May I please, my lord? Here, my lord, the petitioners all are senior citizens, my lord. Their land has been utilized for construction of Kusuma Pond, that is at Jajpur, my lord. What happened, my lord? To assist this honorable court, those are so many dates. I want to take your lordship to my date chat, my lord.
What is the relief just in?
Yes, my lord. Bird's eye view of the case is that since 1928, the 1928, it is recorded in the name of the father of the petitioner and petitioner number 2 to 3 and husband of the petitioner number 1. Thereafter, my lord, in the year 1981, the settlement operation started. There, the petitioner found that the entire area of the Sabik Khata is more than 1 acre. During the Hal settlement, they reduced it to 70% and recorded as 30% area, which the petitioners had bring it to the notice of the ASO and lodge a complaint. The ASO directed for Amino to inquire into the matter, and under Annexure 2 and 3, the Amino recorded that yes, the Sabik Khata number 7 and 10 area has been in the Kusuma Pond. Thereafter, my lord, the ASO had not done anything. Thereafter, after publication of the Hal Pata, the petitioners challenged it before the commissioner. And in RP case, the commissioner said that in the meantime, the settlement operation has been finished. So I don't have any manpower to do the physical verification. That's why under annexure, my lord 5, he had directed the Tahsildar. He remanded the revision case and directed the Tahsildar to consider. It is categorically stated that if my lord will go through page number 29, which starts from 28, annexure 5, my lord.
No, your prayer portion, it indicates that you are praying for payment of compensation.
Yes, my lord, I am confined to that, my lord.
For all these plots.
Yes, my lord.
You mean to say that you have not received any compensation?
That I want to clarify, my lord. The entire area is more than 1 acre. After Hal Khata, it has been reduced to 30%. That is 0.387 decimal. That area is recorded in my Hal Khata, and that area out of 50% I have sold to a private party, and another 50% the state had taken that during following the acquisition process. But this area, which is more than half acre, they are not giving me that compensation amount. So, my lord, in the category cat and half distance, this honorable apex court observed that in compensation part, the state, it is coming under Article 300A. The state cannot take away the land.
Has been filed by the petitioners with following prayers for them. The land counsel for the petitioner submits that, which is the main ground, in the ground you have taken?
During settlement operation,
During settlement of this
the
operation.
land has been reduced.
Yes, my lord, that has been reduced.
Paragraph?
In paragraph,
Paragraph 12,
detail I have given in paragraph number, page 10, my lord.
page 10, right?
It's actually, it
No, no,
starts,
it-
sorry, my lord, it starts from page 9, my lord. Details I have given. Am I permitted to read?
No, just tell us that.
Yes, my lord, paragraph 9.
Paragraph 9.
Sorry, page 9, sorry, my lord, page 9.
Page 9,
Page 9,
which
madam.
is the continuation of paragraph.
Paragraph 8, my lord, sorry.
In different paragraphs of the writ petition, the petitioner has stated as to how they are entitled to get the compensation. Issue notice on the question of admission, indicating therein that the matters shall be disposed of at this stage of admission. Land counsel for the state accepts notice on behalf of all the opposite parties. Extra copies of the writ petition be served on the land counsel for the state within a week. Matter be listed 4 weeks after. Yes.
Item 21.
Where is that, Mr. Misra? Where is that, Annexure 2?
12. Here, at page 59. For your lordship, in the petition number, WPC number 3525 dated of 24, dated 14/24, directed to dispose, permitted me to file a representation and directed them to dispose of the same. Now, without doing that, they approach the collector, and finally, after filing of the street application letter, now a sale notice has been published for auction.
So at this stage, how can we entertain a writ petition in view of the catena decision of the Honorable Supreme Court when the sale notice has been issued, Bafna Motors case recently? You have an alternative remedy lies.
I will not do that, but if it is in violation of your lordship direction,
You can take that ground before the state court.
cannot be.
Cannot, because
Why is
all
not-
those things, whether
Not
that has been
application.
complied with, not all these things, they said that once a particular stage is reached, then the court should not entertain. It should be left to the alternative, that means the DRT, to deal with all these things.
If, when your lordship specifically directed to disposal of the, can you see that order?
It's all right, there was a direction and it was, but.
I filed my representation without considering the same.
No, you might be saying that it has not been considered. They may come and say that it has already been disposed of, order has been communicated, and and we have already proceeded, and this is.
Let them say
Question is
that,
that-
no, they have
No,
not done
question
that.
is that,
Why specifically
once we
argument?
know that a particular, your grievance is mainly on that sale notice, which is
No, I-
dated,
I wanted by the representation dated 14/3, sorry, 12/4 may be disposed of. In terms of your lordship order dated 14/3. That
but
having not
when
been
we
done.
find that orders have been passed on 14/8/2024, you just come to that annexure 14. It is the, that is the
Yes,
sale notice.
my lord. No, that is the notice to, tell notice.
Sale notice ଟା ପରା।
ଆଜ୍ଞା।
ତାପରେ କଣ ହେଲା?
ତାପରେ ସେମାନେ ଗଲେ collector ପାଖକୁ।
କାହିଁ ସେ order କାହିଁ?
That is page 77.
77, let us see that. 77 ने section 14 Surface Act proceeding already initiate ହେଇଗଲାଣି ଏବଂ initiate ହେଇକିନି possession 14 ରେ ଆପଣଙ୍କର direction ଦିଆ ହେଇଛି the superintendent of police to render necessary cooperation, right? So if that stage has reached, then how you are without assailing that the section 14 ଆପଣଙ୍କର proceeding को ଆପଣ assail କରୁନାହାନ୍ତି, ଆପଣ କହୁଛନ୍ତି ତା ପୂର୍ବର ଗୋଟେ କଣ ଆପଣ representation ଦେଇଥିଲେ ତାକୁ dispose of କରିବାକୁ.
Your Lordship directed on 14(3).
It's all right, but
Before I filed my representation, now keeping the representation in one side, they're proceeding. They're approaching the collector under section 14 for rendering necessary assistance.
so when you submitted your application?
But 12/4.
12/4/2024.
My lord.
So
And this, annexure 14 is 14(8). My only limited is that let them consider my application dated 14/12/4 and regarding OTS and etc. But I'm also willing to deposit the OTS amount.
that we cannot
that I-
entertain this writ petition. This writ petition has been filed by the petitioner so and so with a prayer for a direction to the opposite party number 5, branch manager Union of
One more thing is.
Union Bank of
the
India.
petitioner is totally bedridden in hospital. The a portion of the leg has already been amputed.
All those, you place all those sympathetical matter for consideration before the alternative remedy and they will consider. Look on, so and so, for disposal of the representation dated 12/4/2024, which has been filed in pursuance of the order dated 14/3/2024 passed by this court in WPC number 3525 of 2024. During course of argument, Mr. Mishra brought to the notice of this court that proceeding under section 14 of the Surface Act has already been initiated in the court of collector and district magistrate Bargarh, and order has been passed on 12 June 2024, directing the superintendent of police, Bargarh, sub-collector Bargarh, and Tahsildar Bargarh to render necessary assistance to the petitioner, that is authorized officer Union Bank of India Bargarh, branch Bargarh, to take over possession of the secured asset stock. Procedure since substitute you of motors and then alternative remedies available, we are not inclined so also disposed of. Yes, next.
Item 22.
Change exactly correct for these position. Yeah.
23 also same.
23 same.
Item 24.
Item 24. Permitted to withdraw with liberty to file appeal.
Why don't you file a memo?
By substituting a xerox copy, the original.
No, it's all right. Please file a memo and mention that about the permission. Files a memo seeking permission to withdraw this, to refile this, better application for example. The certified copy, of which you want to take return? Interim, that is, Acha. The certified copy of the judgment, impugned judgment for that, under annexure 1. We return to the land council for the petitioner on being substituted with his xerox copy. Yes. Memo is taken on record. Memo did you?
Yes, sir.
Item 25,
Sir, on behalf of Mr. Procedural,
It's not under Annexure 8.
not under Annexure 8 may be possible.
All right, Annexure 8 is the representation to be disposed of.
item 26,
Your Lordship, in item number 26, I am appearing on behalf of the counsel for the petitioner. The counsel of the petitioner could not be present due to ill health. He has requested if this matter could be taken up tomorrow or any other short date subject to convenience of this.
You are appearing for whom, Learned Counsel?
Mr. Binoy Kumar Mahanti, the counsel for the petitioner.
Okay, you are appearing for?
The bank.
So 1, 2, 3, all the opposite parties.
What do you want to give to this court? Oh, you have not received the copy. All right, ask Mr. Mahanti to serve a copy of the petition on the Learned Counsel who is appearing for the opposite parties.
Much obliged, Your Lordship.
All right. Wakalat number again. Mr. Sangram Kesari Burma and his associates file power for the opposite party, which is taken on record. The names of the Land Council be reflected in the cause list and so stop. The Land Council for the opposite party submits that a copy of the writ petition be served on them, on him for them. The Land Council position on opposite party. Huh? What is your good name? Mr. Sangram Kesari Burma. Submit that he has not received a copy of the writ petition. No? Let a copy of the writ petition be served on Mr. Burma during course of this week.
Much obliged.
Matter be listed next week. Yes.
item 27,
Yes, Mr. Mishra.
The above of the real estate appellate tribunal is under challenge before your lordships. That order is at Annexure 3. But I am an allotee of a flat. And the opposite party number 1 is the builder. I moved the RERA asking for a refund of express payment of 13,60,000, which the builder took from me over and above the consideration. That application was allowed. And the RERA held that it is an ongoing project because objection was raised by the builder that since it is a project completed since 2011, this Real Estate Act is not applicable because it came in 2016. And he also disputed that I have never received excess money. The RERA, by appreciating the materials and the receipts submitted by me, held that yes, you have taken excess money, 13,16,000, 60,000, you refund it with interest. And the RERA held that it is an ongoing project because completion certificate was not submitted by them. Then the builder went up in appeal. And the appellate authority, the Orient, remanded the matter on the premises. You will also may kindly see that order at page 58.
Operative portion is page
58.
58.
58. It starts from 57.
No, you say that you are challenging Annexure 3.
Yes. Annexure 3 on the impugned order, you will at 190.
Order dated 12/11/2024.
2011-24.
2011-24 is in page 119.
190.
এইটা কোন কହୁଛନ୍ତି ମୁଁ ଦେଖିବା
সেটা প্রথমে ওরিয়েট जो গলে ওরিয়েট जो রিমান্ড করে
ହେଲା ସେ ତାପରେ କଣ ଏବେ କଥା କୁହନ୍ତୁ ମୁଁ
ওরিয়েট রিমান্ড কলা পরে ওরিয়েট রিমান্ডেড on the premises that the builder submitted 2 documents before the appellate authority showing that the project was complete. So on that ground, whether the act is applicable to the fact of the case or not, so matter was remanded. Thereafter, RERA
again reaffirmed its finding that it is an ongoing project.
Refund that.
Yes. And thereafter, the Orient, in the second round of appeal, he held that yes, it is an ongoing project and the act is applicable, but he disbelieved the receipts which I submitted and said that only I am entitled to 1 lakh rupees and the rest amount is to be refunded to the builder, which the builder deposited before the appellate appeal.
Yes.
Page 124, your lordship may kindly see paragraph 8. Because the first point that applicability of RERA Act, the Orient also confirmed, yes, it is applicable. Now coming to the point of payment of dispute between the parties, the claim of the respondent number 1 with regard to an excess payment of rupees 13,60,000 has been stoutly disputed by the applicant. The learned authority's observation that the said excess amount has been paid by the respondent number 1 to the appellant, and therefore the latter is liable to refund him the same together with interest is under challenge in this appeal. Admittedly, the agreed consideration price of the flat number so and so project sold to the respondent is 20,40,000 as reflected in the sale agreement dated so and so. The appellant has executed the sale deed in respect of the flat in favor of the respondent on 27/7/11. And the sale deed discloses that on the date of its execution and registration, the entire consideration amount 20,40,000 had been received by the appellant in shape of cash and check on different dates. The respondent number 1 has alleged that the excess amount of rupees 13,60,000 was paid due to the insistence of the appellant for further payments for the purposes like finishing work, enhancement of plinth area, stamp duty on excess payment to meet the evaluation, etc. Money receipts dated 6/10/2009, 4/5/10, 16/9/11, 3/6/10, and 3/6/10 for the amounts of rupees 5 lakhs 40, 5 lakhs, 1 lakh 50, 3 lakhs 50, and 5 lakhs, respectively issued by the appellant with its printed name and address at the top in favor of the respondent are all undisputed documents. It is the claim of payment of cash of rupees 4 lakhs on 8/9/2008, 1 lakh on 24/7/9, rupees 2 lakhs on 9/8/2009, rupees 3,60,000 on so and so, made by the respondent number 1 to the appellant, which are in dispute. The respondent number written acknowledgement on a plain paper with regard to receipt of a total amount of 7.
They're challenging the genuinity of the document.
How, Mr. Mishra, ये जो disputed जिन सोडा का read petition है क्या कि अपन करो?
He appreciated.
No, even if he appreciated, he said that it is genuine, and appellate authority says it is not genuine. So, what is the way out?
Evidence requirement नहीं कि
Evidence अपन देवे नहीं. How? So, what is the extent of it?
केमती disputed जिन सोडा को विचार गुड़े जो document genuine की नहीं, तादर parties evidence adduce करिवा दरकार, issue जिन सो केमती read petition ले.
And what is the extent of the power of the appellate authority or the RERA, whether they can adjudicate a matter by taking evidence?
No, it is limited jurisdiction.
Then you have to go to the civil court.
Civil court, my claim may be barred because of RERA.
That is different, but you are already there now, before the court.
So, my humble submission, they may, in all fitness of things, there should be a further remand, at least for verification of these documents. Because I produced.
No, RERA order was passed on which date?
RERA order passed in.
And the last order has been passed on 23.
Yes, ma'am.
So how do you say that it is time barred?
No, time barred. RERA act to the bar is civil court jurisdiction ta.
Bar hichi. That is why. No, civil court ra yeta bar hichi on the subject matter where the RERA is to act upon. But where the genuinity of a document,
a particular document,
that is within the domain of civil court.
Not my humble submission. I submitted some documents, some receipts. Then it is for the builder to report those receipts.
What is the mode of rebutting it? By adducing evidence? No. Can they do it? If they can do it, we'll give a direction.
He should have done it. Builder should have done it. And now the builder gets a premium and I am paying excess money. I will be running from pillar to post.
But how
the
can
question is that we are in in the jurisdiction, how we can adjudicate whether a particular document is genuine or not, whether this disputed question of facts, whether this can we adjudicate this matter. You are right that against that order of this passed in the so and so, and the writ petition is maintainable, that's a different matter. But the nature of relief which you are seeking from us, it relates.
Another submission, madam. The first round appeal before the Orient remanded only on the ground that to verify whether the act is applicable to not or not. So this part of the claim, this part of the order, my entitlement to refund becomes final.
Just Mr. Just think over it. We can take up this matter day after tomorrow if you amukar darkar je kemti ame ei jo jinsa apna entire thing is disputed apna je auchani ame kemti ame ha ame adjudicate kariban sei to question was ha day after tomorrow rakhiba. All right, put up this matter day after tomorrow, that is on 8th of January 2020. Yes.
Item 28.
Matter, the petitioner who is the loanee, he challenged the e-auction notice before the DRT, and DRT has deposited the demand notice. E-auction notice demand is already deposited 7,50,000, and thereafter, DRT posted the matter for order, but no order has been passed as on date.
Code is the code and the order code.
Now, kindly have a glance to page 39. 39. Ask the learned DRT.
Yes.
Page 37 there, she called 11,4,2023. The deposit amount has been reflected.
Two codes, right?
Page 37.
37.
On 11/4/2023. I'm
Yes.
reading the order. And counsel for the appellant present, learned counsel for the respondent bank present, and filed counter and copy shot to the other side. Learned counsel for the applicant so moto filed memo along with demand drafts, bearing number so and so, dated so and so, for amount 12,10,000, DD number so, dated so and so.
These are all as per the order passed by the DRT.
Yes.
So you deposited the demand draft.
Yes.
That were kept on record.
Yes.
Then what further order was passed?
And bank also accepted that contention.
Okay.
And but the matter was kept for order, but no order was passed as on date. And your lordship.
No, you made a prayer for stay of the auction.
Yes. But auction took place, nobody participated. Now what happens, because the long pendency in spite of payment of the amount, and page 36, bank admitted that I have deposited, page 36. They have issued letter, 26/2023, saying that the total amount deposited at the DRT 17,50,000.
No, Mr. Bali, এই যে অর্ডারটা আপনি ଦେଇଛନ୍ତି লাস্ট অর্ডারটা সেটা দেখুছি যে এই কেসটা ফ্রম টাইম টু টাইম ଆର୍ଜିଅନ୍ ହଉଛି ଏବଂ ଗୋଟେ ଡେଟ୍ ଅଛି ଲାଷ୍ଟ ଡେଟ୍ଟା ଦେଖନ୍ତୁ ଯୋଉଟା ଆପଣ ଦେଇଛନ୍ତି 25/11/2024 ପେଜ ନମ୍ବର 40 କୁ ଆସନ୍ତୁ। Page number 40 ରେ ଲେଖା ହେଇଛି honorable presiding officer is on leave today. The matter is adjourned to the date fixed put up on 24/12/2024 for hearing. ତେଣୁ ହିୟରିଂ ଏ ମ୍ୟାଟରରେ ଏପର୍ଯ୍ୟନ୍ତ ଆରମ୍ଭ ହେଇନି।
ନାଇଁ ପେଜ 39 ଟା ତା ପୂର୍ବ ଅର୍ଡରଟା ଦେଖୁନା ପେଜ 39 30/9/2024 put up 28/10/2024 for order.
No. ସେଦିନ ବି not that was hard. ସେଠି ପୁରା ଉପରେ ଲେଖା ହେଇଛି honorable presiding officer is on leave today and the matter was adjourned.
ଆଜ୍ଞା ପେଜ 43 ଟା ଦେଖନ୍ତୁ ତିନିଟା ଡେଟ୍ ଅର୍ଡର ପାଇଁ ରହିଲାଣି।
ଅର୍ଡର ମାନେ କି ଅର୍ଡର ସିଏ?
ମାନେ ଫାଇନାଲ ଅର୍ଡର। ସେ କହିଲେ ପା ଯୋଉ ଫାଷ୍ଟ ଯୋଉ DRT କହିଲେ bank instruction number to liquidate the loan.
ସିନା ଆର୍ଗୁମେଣ୍ଟ ଶୁଣିଲେ ସିନା ଅର୍ଡର ପାଇଁ ରହିବ।
ଆମର affidavit ସବୁ hearing ସରିଛି। Hearing ବି ସରିଛି।
No, on 1/8/2023 for arguments. Then it is adjourned. Then where is the hearing and argument?
Argument ପରେ order ପାଇଁ ରହିଲା।
Argument hard ବୋଲି କୋଉଠି ଅଛି?
ଲେଖା put upon for argument। ତାପରେ 39 ରେ after hearing orders ପାଇଁ ରହିଲା। এটা କହିଲେ ରହିଲା for order।
39/2024 ପରା
PO ନଥିଲେ?
ଛୁଟି ପିଓ ନଥିଲା ଆଉ ଆର୍ଗୁମେଣ୍ଟ କାହା ପାଖରେ କଲେ କଣ ଏଇ ଯୋଉ ୟା ପାଖରେ କଲେ କୋର୍ଟ ମାଷ୍ଟର ପାଖରେ ନା
ସେଟା ଅର୍ଡର ଆର୍ଗୁମେଣ୍ଟ ସଇଲା ତାପରେ ନେକ୍ସଟ ଦିଟା ଡେଟ୍ ରେ ହିୟରିଂ ହେଇକି ଅର୍ଡର ପାଇଁ ରହିଲା
Acha. So on 39/2024, the matter was posted for order.
predicament is that କାହିଁକି ନା ସେମାନେ ଯେହେତୁ ଫାଇନାଲ ଅର୍ଡର ହଉନି ବର୍ତ୍ତମାନ ସେମାନେ ଇ ଅପସନ ପାଇଁ ଗଲେଣି
ବର୍ତ୍ତମାନ 24/12/2024 ରେ କଣ ହେଲା
24 ଦିଆ ଫେର ସେଟା ଆର୍ଜନ ହେଇଗଲା
ପୁଣି ଆର୍ଜନ ହେଲା
ବ୍ୟାଙ୍କ ଟାଇମ ନେଇଗଲା
ଆଚ୍ଛା ବର୍ତ୍ତମାନ କଣ ହେଲା ବର୍ତ୍ତମାନ ଆପଣ ଅସୁବିଧା କଣ ଅଛି
ବିକଜ ସେମାନେ ବର୍ତ୍ତମାନ ଫର୍ଦର ମୋର ଭାଲୁଏସନ କରିକି ଇ ଅପସନ ପାଇଁ ଗଲେ
କାହିଁ ସେ ଇ ଅପସନ ନୋଟିସ କାହିଁ
ଇ ଅପସନ ନାହିଁ ମତେ ଫୋନ କରିକି ଆସିଥିଲେ ଭାଲୁଏସନ ରିପୋର୍ଟ ନେଇ ଗଲେ
ଯଦି ହବ ଆପଣ ସେଠି ଇଣ୍ଟରିମ୍ ଆପ୍ଲିକେସନ ଦଉନାହାନ୍ତି ଯେ
ରେସିଡେନ୍ସିଆଲ ହାଉସ ଟା
ଆରେ ବର୍ତ୍ତମାନ କିଛି ଆପଣଙ୍କର
ଟାର୍ଗେଟ ତ ରିଆକ୍ଟି ମ୍ୟାଟର ଦ୍ୟାଟ ନେକ୍ସଟ ଡେଟ୍ ଅଛି 14/1/2025
ସେ ପ୍ରିଜାଇଡିଂ ଅଫିସର ଲିଭ ରେ ଥିଲେ ଜଏନ କଲେଣି
ହଁ ହଁ
ଠିକ ସେ ବୁଝନ୍ତୁ ନହେଲେ
ଆଜି ବି ଛୁଟିରେ ଅଛି
କଣ ଖାଲି ତ ଲେଖା ହଉଛି ପ୍ରିଜାଇଡିଂ ଅଫିସର ଇଜ ଅନ୍ ଲିଭ ସବୁଦିନ ଲିଭ ରହୁଛନ୍ତି
ନା ପେଜ 41 ରେ ନେକ୍ସଟ ଡେଟ୍ ଅଛି 14/1/2025
ଆମେ ଏଇଟାକୁ ପହର ଦିନକୁ ରଖୁଛୁ ଜଷ୍ଟ ବୁଝନ୍ତୁ ତାଙ୍କର ଲିଭ୍ କୋଉ ପର୍ଯ୍ୟନ୍ତ ଅଛି କେବେ ଜଏନ କରିବେ ତାହେଲେ ଆମେ ଗୋଟେ ଡେଟ୍ ଦେଇପାରିବୁ ଯେ ତାକୁ ଶୁଣିକିନି ଡିସ୍ପୋଜ ଅଫ୍ କରିଦିଅନ୍ତୁ ଟାଇମ ଗୋଟେ ଦେଇଦବୁ ହେଲା let us put up this matter on 8th of January 2025 as ठीक है 9th of January 2025 as prayed for by the Learning Council for the petition.
For orders, item number 29.
मेरा कौन सा है
ଆସିଛି ଆମ ପାଖରେ second appeal date.
ଆଉ ଗୋଟେ ଦିନ ରହିବ ତ
Chief Justice ଏଟା ଆସିଛି
ଏଟା ନନ୍ ଆপিୟସ୍ କରିଦେଇକି ଆର୍ଜନ କରିଦିଅନ୍ତୁ ନେକ୍ସଟ
Item 30.
ଆଉଥରେ କୁହନ୍ତୁ So you are to provide complete address within 1 week, 15 days time. All right. The SR of notice on opposite party number 3 has written unserved with postal remark incomplete address as inverted comma with Learning Council for the petitioner seeks 2 weeks time to file press requisites
against opposite party number 3
on opposite for with complete address of opposite party number 3. Hello? All right.
Instead of serving 2 extra copies of read petition to the state, we inadvertently sought 2 extra copies of the same appeal.
of CM appeal.
Same appeal.
Instead of
same in the course of the day, we find
the Learning Council for the petitioner submits that he will supply the 2 extra copies of the writ petitions on the Learning Council for the state in the meantime. All right. Is this matter the date they will say you yes.
Item 31.
The file and memo to withdraw matter.
Okay, the registry has perhaps pointed out that it should be an IA. All right, we are accepting the memo and disposed of as withdrawn. Yes. No, have you mentioned in your memo?
Yes, prayed for.
As prayed for, the liberty as prayed for. Granted. Yes, next.
Lion for the appeal.
The Land Council for the opposite party is present. Well, yes.
Item 32.
But I will cite some modification of order dated 18/12/2024 manner.
Yeah.
Paragraph 3 manner.
Instead of 23/3/2022, it would be 16/3/2022.
How so ठीक अछि?
How so ठीक अछि?
All right, there is an area for modification of the order dated so and so. The Land Council for the petitioner submits that in the order dated 18/12/2024, in paragraph number 3, inadvertently, in the fourth line of paragraph number 3, the date has been mentioned to be 23/3/2022 instead of
16/3/2022.
16/3/2022. The same may be corrected. Stop. Land counsel for the state has no objection. Accordingly, the date as mentioned in fourth line of paragraph number 3, as 23/3/2022 shall be read as segues.
16th.
Ungrateful, my lord.
IA is disposed of.
Ungrateful.
The rest of the matter will come.
Lord, may I mention, Lord, the next matter is, my Lord, a matter where on the last date of hearing, your lordships were kind enough to ask the government, my lords, to take instructions and come back.
It will just come tomorrow, Mr.
Pass over to
It will pass over to tomorrow. It is not, nobody is taking out any matter from the list. It is just, it will just be, because after lunch, there is a separate list altogether.
Very well, Lord.
Okay?
Very well.
The rest of the matter will be taken up tomorrow. Bail ପାଇଁ application ଦଉଛନ୍ତି. Please give it.
Weekly list item number 1.
Yes.
The appellant earlier on order dated 2/9/24, he released on bail for 3 months, and in the meantime he surrendered. The surrender certificate not yet received. So my lord, kindly paying for an adjournment to.
But you are sure that he has surrendered?
As per instruction, he surrendered. So I have to obtain the certificate.
Right. This year, number 28 of 2015. The land counsel for the petitioner appellant submitted that after availing the interim bail period as per order dated so and so, the appellant has already surrendered as per the instruction. But some more time is required to produce the surrender certificate. Stop. List this matter 2 weeks after the date given. In the meantime, a report be called for from the London trial court as to whether the petitioner availed the interim bail period for all of the response and surrender right time or not. Report be received and date fixed. Yes.
Item 2.
There is a IA has been filed for bail. Copy may be solved. IA 2844 of 24.
How many appellants are there? So, the noting has come, Mr. Somnath Nanda, you are there. So you have filed appearance, no, wakalatnama for whom?
For two.
For both the.
Including previous council.
All right, have you not given the copy of the interim application? Give a copy which can be taken off next week. How many years the petitioner has in custody?
4/6/2013.
You obtain the custody certificate also, huh? IN number.
Beg pardon, ma'am. I am for the informant. After death of the Mr. Naik, I have been misplaced. I play for 2 weeks time so that I can collect the documents.
No, you can, if you are appearing, you can take in your pen drive. You can get it. There is no problem in that. Mr. B.C. Parija, Land Counsel for the informant, submits that he may be supplied with the brief in his pen drive, that the registry supply the so in the pen drive of Mr. Parija. Stop. IN number so this is an application for bail. Land Counsel for the appellant submits that the appellant is in judicial custody since 2013. 4/6/2013. The Land Counsel for the state submit that he is yet to receive the copy of the bail application. Let a copy of the interim application be served on the Land Counsel for the state by tomorrow, and matter will be listed on such and such date. Custody certificate be obtained in the meantime. Who jail lachandi se mane? Who jail lachandi? Sundargarh. Yes. All right. All right.
Deposition copy pen maybe.
Acha, good काम करूँगा. Both these petitioners were on interim bail.
One.
It's appellant number 1.
In 2020.
Okay. Next.
Item 3.
ऐसे थोड़ा सुबुनी कौन है
Custody about 10 years in jail custody lordships. They are both appellants of these others, sons are brothers, my lord.
No, what is the years of?
26/2/15, my lord.
26/2/15. Yes. Are you having this custody certificate with you?
The
evidence copy should be supplied.
already supplied.
Oh, is it coming for the first time?
Yes.
Earlier that was
Copy supplied.
admitted.
After receipt of trial court order, it was taken.
Deposition copy आपनकर अच्छी तो?
आगे.
Deposition ये अपन कितने साल देवे? अब बाकी में pen drive नहीं हो. He is showing the documentary proof that it has been served in your office. If you have missed it, then collect it by in your pen drive. The trial court record is here. IN number so and so, but obtain that custody certificate. IN number so and so. This is an application for bail. Single appellant.
Double appellant.
Appellants for them. And you have filed the bail application for both the appellants.
Yes, yes.
submit that the appellants are in judicial custody since Quebec government
26/2/15 my lord.
26/2/2015. And counsel for the state took some time to produce the custody certificate. Is this matter? Answer, answer, yes.
Item 4,
In this case, my lord, last time my lordship called for the report regarding the conduct report laws.
कौन आपकी को ना दी और पेपर टाउन नहीं था
He was in judicial custody. Honorable court granted for a period of 3 months interim bail with concern that he was during time of interim bail he was residing at his native village with peaceful manner. His conduct was good and no adverse report had been.
Dion properties ना केबे जाइतिले आपण इंटरिम बेल ले तीन मंथ जाइतिले
Yes, my lord.
23/7/2024. So you are in custody since 6/1/2016.
My lord.
No, that's 302 ना 302 307 Town to eta initially registered एक town कला 302 307 में से मरला और ये बिकन हमने मिसयूज नॉर्मल कला था कुछ हाँ otherwise no we forget to just come to rely for IN number 264 of 2024. There is an application for bail. The petitioner was granted interim bail for a period of 3 months. As per order dated 23/7/2024 in IN number 21 of 2021, taking into account his period of detention in judicial custody and also keeping in view the ratio laid down in the case of Leti alias so-and-so reported in so-and-so. After availing the interim bail period, the petitioner has surrendered and the learned counsel for the state has produced the report dated 5/1/2025 from the officer in charge of Judicial Police Station, District Bhadrak, that during the time of interim bail release, the petitioner was residing at his native village in a peaceful manner and his conduct was good and no adverse report has been received against him. So, in the case of Leti alias Jagdev Rai, supralation, it is held, relevant paragraph of court process, which requires the misused of perfume that are T level. In view of the aforesaid so-and-so, since the petitioner has not misutilized the liberty while on interim bail and for the taking into account the period of detention in judicial custody. And since paper book has not been prepared and there is no chance of early hearing, we are inclined to release the petitioner on bail allowed.
Item 5.
Item 5 can be taken on next week.
Item 6.
Item 6, Your Lordship directed me to produce the custody certificate. But it is there, but my lords, I found there is some wrong mentioning, my lords, where it has been mentioned that he has not been convicted. So my lord, I found it is
Not convicted.
wrong information has come. Lordship, admittedly, he is a deaf and dumb person, and he is in custody. During the trial, he was there 9 years, 7 months.
To get it next week.
Yes, my lords, yes,
The Learning Council for the state submits that though he has received the custody certificate, that it needs some clarification and the matter may be taken off next week. Please, this matter on 13th January 2025. So Tushar Kant Mishra, Land Council for the appellant is present. Land amicus is present. Yes.
Item 7.
Mr. Japula.
Affidavit with regard to the criminal antecedents of the appellant, my lords. I filed it today, my lords, before the registry. And
Have you served a copy?
right now, I'm sorry.
Land Council for the appellant submits that as for the order dated he has filed a comprehensive affidavit relating to the status of the criminal cases instituted against the petitioner today before the registry, and he has handed over the copy of the same to the Land Council for the state in court today. Wants to obtain instruction on the same, put up this matter on 20th of January 2025. Registry shall place the comprehensive affidavit on record. Yes.
Item 9.
Implement foundation next. Mr. Nayak, Land Council, the appellant sits for an adjournment till next week, 13/1/2025.
Item 10.
Mr. Saroj Kumar Rautray. Non-appears to next week, a week after. 28/1/2025. Yes.
Item 11.
Business person or something. Oh,
Why is not appearing? Now the clear, yes, she will. A common complicated version now, huh? खाली हमें अर्जेंट कर दो कि लेखन उसे appear करना very intimate. Put up this matter on 20th of January 2025.
Item 18.
You got that decision, item number 18,
My lord,
about the sufficient in ordinary course of nature.
my lord.
Data set ଦେଇଛନ୍ତି?
My lord. Madam, may I submit another?
Have you
thing?
given the reference to the Land State Council
My
also?
Opinion?
Madam, may I submit one thing?
Yeah.
Have a glance on the PW3, my lord.
Opinion?
Mr. Pradhan,
My lord.
is it, this decision has not yet been reported or what? Uppuda, Ubendu. Who paragraph ଅଛି?
Paragraph ଟା କହିକି ଦେଇଦେଉଛି ଆପଣ।
What a detailed discussion ହେଇଛି ତାପରେ।
My lord.
Paragraph 10, page 21 ରୁ ଆରମ୍ଭ ହେଇଛି। You go through this decision, Mr.
Para 10 and 11 is important.
304 part 1 ହେଇଛି। ये କେତେ ବର୍ଷ ରହିଛି?
Perhaps 10 years.
No, the present applicant.
Present applicant କେତେ ବର୍ଷ ରହିଛି? Final form ଟା ରହିଛି। या ना कौन?
2009.
Europe के होनी।
Since 2009. my lord.
1/3/2009.
My lord.
Bill जाएगा तो है तो accused is produced. No. ଏଠି ହାଇକୋର୍ଟରେ ବିଲ୍ ଯାଇନି କ୍ରିମିନାଲ ଅପିଲରେ ଦେଖିବ ନା ବାହାରେ ଆଡମିସନ ହେଇଗଲା
बारह एडमिशन और ये कहीं की जजमेंट टाइम की जजमेंट तो नॉट
ହଁ ତାପରେ ବାହାରେ ଛାଡ଼ିଥିଲା ଯୋଉ କ୍ରିମିନାଲ ଅପିଲ ଆଡମିସନ ହେଲା 13/2/12 ତାପରେ ଆଉ ଚୁପଚାପ ବସିଗଲା କିଛି ନାହିଁ ତାପରେ 2024ରେ ଆସିଲା ରୁଲିଂ ପାଇଁ
ଯେହେତୁ ଆମେ ଡେଟା ଡିଏରେ ଦେଲୁ ଆମେ ପ୍ୟାନେଲରେ ଦେଲୁ ନା ଆମେ ବାହାର ନଥିଲେ ସେ ଆସିନି ଜେଲ ବି
So the doctor is PW.
PW4, my lord, who conducted the PM.
So he has stated to have noticed 3 lacerated wounds. But he has stated that the death was on account of these injuries and but cause of death is stated that it's but he has not given that opinion that it is sufficient in ordinary course of nature to cause death. The injury was caused by wooden plank, right? MO1 and the 3 injuries are there. There are 2 eyewitnesses to the occurrence. One is
PW3.
One is PW3, madam.
PW3,
Another
who has though stated in the examination in chief that one blow was dealt on the head, as a result of which the appellant lost the sense But the learned defense counsel in the cross-examination has perhaps brought out that more number of blows were given.
Three stated about 2 blows, 6 stated about 1 blow.
Acha.
But in the cross-examination, it was
Cross-examination it
brought.
has been. Cross-examination. Anything you want to submit?
My lord.
But
If lordship permitted, my lord, have a glance on the PW3, my lord.
yeah.
My lord. PW3 on para 3, my lord. On the last person, on the second page, running page 40, my lord, he was stated that I turned towards the accused and forcibly captured him. In that process, the accused beat me on my right hand. The PW3 is the main witness in this case, my lord. Who stated categorically stated the accused beat me on my right hand by his tail. The blow aimed by the accused to my head hit me on the back. And again, have a glance on PW7 who treated PW3, my lord. On para PW7, my lord. Para 3, my lord. On top line 3, one of the injury described in the requisition were not found on the body of the injured during my examination. No definite teeth mark was visible on the side of injury number 1 described in Exhibit 8, my lord. PW7 who examined the injured, my lord.
Yes, so he found 2 abrasions.
3, para 3, my lord, cross-examination. My lord. One of the injury described in the requisition were not found on the body of the injured during my examination. No definite teeth mark was visible on the side of injury number 1 described in Exhibit 8. So that it is the PW3 is not trustworthy witness. The same was stated by PW6 who was the father and son. PW3 and 6 is the father and son. Other eyewitness also present in this occurrence, my lord. Have a glance on the IO statement. And he himself stated PW3, my lord, in para 6, my lord. On the last person, I never made the sarpanch after the occurrence. One Debraj Sahu is the proprietor of the shop situated near the spot. When we raised hulla seeing the act of the accused, many persons gathered at the spot. Arjun Pradhan, Nauri Dehuri, and my Nauri Dehuri and Arjun Pradhan. And many persons also present at the time of the occurrence. Other eyewitness also present, but not a single person examined in this case. Only son and father examined in this case. And as per the IO, he arrested the accused on the next day. It is also a doubtful situation, my lord.
Yes.
If the PW3 is the not trustworthy witness, my lord,
PW?
the accused be acquitted. PW3.
Why is not a trustworthy witness?
He himself stated that bite injury is there, but as per the doctor report, my lord, doctor says that no teeth injury is there, my lord, on the cross-examination. PW3, my lord, have a glance on the para 3, my lord. Para 3 on the last person, he was stated that the accused beat me on my right hand by his teeth. The blow aimed by the accused to my head hit me. Beat me on my right hand. Again. No, PW7 stated that no injury, my lord.
Who did?
PW7 who examined the PW3, my lord, Dr. PW7, my lord.
ଯଦି ଇଞ୍ଜୁରିଟା କହିଥାନ୍ତା PW3 ଯେ ଏମିତି ମତେ କାମୁଡିଲା ଯେ ମୋର ମାନେ କଟିଗଲା କି ରକ୍ତ ବାହାରିଲା ସେମିତି ତ ସେ କହିନି ଖାଲି କହିଲା କାମୁଡି ପକେଇଲା ହୁଏ ତ ସେ କାମୁଡିବା
by his teeth ବୋଲି କହିଛି by his teeth ବୋଲି କହିଛି
ଆପଣ ସବୁବେଳେ ବାଇଟ୍ ଟିଥ୍ କଲେ ଇଞ୍ଜୁରି ହବ ରକ୍ତ ବାହାରିବ ସେମିତି ବି ମାନେ ନାହିଁ ତେଣୁ how do you say that ଗୋଟେ ଇଞ୍ଜୁରି ନାହିଁ ବୋଲି ତାକୁ disbelieve କରିଦିଆଯିବ
trustworthy ସେ witness ଟା.
Yes, any other submission?
Any other 6 also stereotypes stated that same thing as per PW3, my lord. PW3, those statements stated by the PW3, the same statement stated by the PW6. He was also stated that
No,
teeth.
they were the eyewitnesses to the occurrence.
My
If they
lord.
were present at the spot,
My lord.
they have seen the occurrence.
My lord.
So whatever they will state, that will match with each other. So why, what kind of submission it is that it is a stereotype? What does it mean by
My
stereotype?
lord, he is the father and son, my lord. But he was
Father and
stated
son.
that some person, after the occurrence, one person come. He was not stated that my son was come.
No, dita jo sakhi ହେଇଛନ୍ତି,
My lord.
ସେ ଦିଟା ସାକ୍ଷୀର statement ଟା ଯେହେତୁ ସେମାନେ ଗୋଟେ ଘଟଣାଟାକୁ ଦେଖିଛନ୍ତି,
My lord.
so ଦିଟା ଯାକ ଘଟଣାଟା ମ୍ୟାଚ୍ କରିବ ନା ତାଙ୍କ ଭିତରେ inconsistency ଆସିବ? ଯଦି ମ୍ୟାଚ୍ କରୁଛି ତାହେଲେ stereotype କଣ ଆପଣ କହିଲେ? ଆଉ ଦ୍ୱିତୀୟ କଥା ହଉଛି ଯଦିଓ ସେମାନେ କହିଛନ୍ତି ଯେ ଅନ୍ୟ ଲୋକମାନେ ଏ ଜାଗାରେ ଥିଲେ,
My lord.
is it the law that all the witnesses who are present at the scene of the occurrence,
My lord.
unless they are examining the prosecution case, cannot be believed?
My lord, other circumstances also created a doubt, my lord.
You are raising a point.
My lord.
We are asking you
My lord.
that whether it is the quality of evidence that counts or the quantity of evidence that counts. As per section 134 of the Evidence Act.
Quality, my lord.
So even if it is said that a solitary witness,
My lord.
if it is found that his evidence is trustworthy,
My lord.
cogent,
My
clear,
lord.
above board, then that can also be acted upon, and on basing on that evidence also conviction can be sustained.
My lord.
So here two witnesses, maybe they are father and son, but they were present and they have stated how the occurrence has taken place, and their with evidence is consistent. That
Right.
means they tallies with each other. There is no contradictions in their statements.
My lord.
So if that is there and it corresponds to the medical report.
My
So then merely because some other witnesses present
My lord.
at the scene of occurrence have been not examined, let us say, by the prosecution,
My lord.
can that be a ground to disbelieve the entire prosecution case and also discard the evidence of PW 3 and 6? Is it your contention?
Well, my humble submission before Lordship, if PW3 is the trustworthy witness, he must said the truth of the fact before the.
So the only aspect of the teeth bite
My lord.
being not consistent to the medical evidence, can it be said that the witness has exaggerated the fact?
But other.
Other injuries are there.
My lord, other circumstances.
Suppose there is no injury and he is speaking that yes, he assaulted me, I sustained injuries, and it is found that no injuries.
My lord, other suspicious circumstances is that the accused was arrested on the next day, my lord. Though all the witnesses stated that we chased on the spot, my lord. It is also doubt
No, he has
whether
been
the
shown
accused was.
arrest.
He has been shown
Shown
to have
arrest
been
on the next
arrested.
day.
My lord.
ଯୋଉମାନେ ତାଙ୍କୁ ଧରିକିନି ରଖିଲେ
My lord.
ସେମାନଙ୍କର ପାୱାର ନାହିଁ ଆରେଷ୍ଟ କରିବା ପାଇଁ, ଆରେଷ୍ଟ କରିବ ପୋଲିସ ଅଫିସର।
I was stated, my lord.
କଣ କହିଲା?
On the next day.
On the next day, I have arrested.
ସେଇଆ
My
ପରା
lord.
କହୁଛୁ, ଆପଣ ପବ୍ଲିକ ତାଙ୍କୁ ଅଟକେଇକିନି ରଖିଲେ, ଘଟଣା ଜାଗାକୁ ପୋଲିସ ଆସିଲା ପରେ ତା ନେକ୍ସଟ ଡେ ରେ ଆରେଷ୍ଟ ମେମୋ ପ୍ରିପେୟାର କରିକିନି ଆରେଷ୍ଟ ଦେଖେଇଲା, ତ କଣ ଅସୁବିଧା ହେଲା ତା ଦେହରେ?
My lord, may I submit, my lord, the IO statement on para 10?
Hmm.
When I reached the spot, the accused was not present there. I did not search for the accused immediately. Since I went to the hospital to see the dead body, it is not a fact that at the time of my spot visit, the accused was found detained being tied by the witness, my lord. But all the witness stated that at that time I chased and tied the accused, my lord.
That is not that a contradiction in that way.
Because some of the suspicion grounds since his case. my lord.
ये आसीची information पाइकिनी investigation करियाकू
My lord.
तारो main object हबो जे केमती medical
Evidence
examination केमती collect हबो सेठी inquest हबो
My lord.
सेठी dead body sent हबो postmortem examination तापरे कारण सेउडा को wait करी परिबनी
My lord.
एठी जदी साक्षी माने अछंती से तो गां को आसी साक्षी मानु को एग्जामिन करबो accused तो already रहिची तेनु accused को परे टिके अरेस्ट कला आगे पळेला थाना को ए जो हॉस्पिटल को इनक्वेस्ट करिवा पई बा पोस्टमार्टम को पठिया पई, can that be a ground to disbelieve the prosecution case?
No, other witnesses also stated that the same person who chased him.
All right, because he was not arrested on the very same day. Can it be taken otherwise? He is to be arrested within 24 hours. Once he is arrested, he is to be forwarded within 24 hours.
It
It to
my lord, it
That
was
was
a
arrest
suspicious
କରିଛି।
doubt whether the accused was present at the time of the occurrence or not.
No, presence of the accused. That you say. Presence of the accused is doubtful, according to you,
My
because
lord.
arrest has been made on the next day.
On the next day, and other witnesses also stated that on the same day of the occurrence, he chased him and tied the accused.
So what is the case of the defense? Who else?
What is your case?
My case, due to political rival, the false case
No,
was
right.
initiated against the present petitioner.
What
my
is your
lord.
suggestion to the witnesses?
Suggestion, the same suggestion, my lord.
Or
Due to the
political is all right.
political rivalry,
That means
the false case was foisted against the present
that
petitioner.
means there is a political animosity between the
My lord,
parties.
my lord.
Where is that? What kind of animosity was there? Was he really a person belonging to a political party for which there was hitch between
It
them?
was suggestion given by the PW3 on the last para, my lord.
ଆପଣ ସିଏ କୋଉ ଦଳର ଡିସିଷ୍ଟ କୋଉ ଦଳର ତାକୁ ଯୋଉମାନେ ତା ନାଁ କହୁଛନ୍ତି ସେମାନେ କୋଉ ଦଳର
No, other vital thing, my lord, may I submit, my lord?
Hmm.
Have a glance on the statement of Sarpanch, my lord.
Sarpanch, PW?
PW5, my lord. He was the person of Sirjia Poda, my lord. My home it has Mouja, Sorisia Poda. On the first column, my lord, the address was dictated, my lord. On the first page, my lord. My lord. Sorisia Poda. Have a glance on the statement of the informant, my lord. The Sarpanch was lost the affair, my lord. Informant was not lost the affair, my lord. Scriber of the affair also. Scriber of the affair was the Sarpanch, my lord. And PW1, who is the informant, my lord, in this case, he stated that one of the gentlemen lost the affair.
ନାଇଁ କଣ ବୁଝିଲାନି କଣ ଆପଣ ସବମିଶନ କଣ କହୁଛନ୍ତି
ଏଠି ଆଜ୍ଞା ସରପଞ୍ଚ ଏଫଆଇଆର ଟା ସରପଞ୍ଚ ଲେଖିଛି ସରପଞ୍ଚ ଲେଖିଛି ସରପଞ୍ଚର ଗାଁ ହଉଛି ସୋରିଷିଆପଦା ଇନଫରମେଣ୍ଟ ଯିଏ ଆଜ୍ଞା ଦେଇଛି ଯାଇକିରି ଏଫଆଇଆର ସିଏ କହୁଛି ଗୋଟେ ଭଦ୍ରଲୋକ ଲେଖି ଦେଇଛି ସିଏ ହଉଛି ଗନ୍ଦିଆର ଆଉ ଗୋଟେ ଗାଁ PW1 କହୁଛି ଆଜ୍ଞା ଇନଫରମେଣ୍ଟ ନିଜେ କହୁଛି PW1 Have a glance on para 2, my lord. PW1, para 2, my lord. A gentleman of Gondia wrote the affair, my lord. That was also suspicion, my lord. The person was Sorishiapada, but the informant was stated that the person was Gondia who written the affair is a gentleman, my lord. Clear cut, it's a case of a political rival. PW, man, para 2, my lord.
Sarpanch କୋଉଠି ଗଲା
Sarpanch was Sorishiapada. PW. Have a glance, PW5, my lord. PW5, my lord.
ସୋରିଷିଆପଦା ଜିପି
My lord. Pradipta Kumar Raut, Khandicharan Raut, Mouja Ramo, Sorishiapada, police station Gondia. Police station ହଉଛି ଗନ୍ଦିଆ କିନ୍ତୁ ଘର ହଉଛି ତାର ସୋରିଷିଆପଦା।
ହଁ ସେ କଣ କହିଲା
ये लोक
gentleman of Gondia road Gondia ତ ଥାନା ପରା
ଗନ୍ଦିଆ ଥାନା
ଗନ୍ଦିଆ ଥାନା ପରା
ଆଜ୍ଞା
କଣ ଅସୁବିଧା ହେଲା କଣ
gentleman
no, he did not take his name, though it is supposed that he should know him as a sarpanch.
My lord,
sarpanch ଗୋଟେ gentleman
for family, his family members, many of the persons also
sarpanch
present.
ସେ କହିଲା gentleman କଣ ଭୁଲ କହିଲା ନା କଣ ବୁଝି ପାଇଲି
ସେ ଗନ୍ଦିଆର ସେ ଲୋକ ନୁହଁ ଆଜ୍ଞା
କି ଗଣ୍ଡିଆର ପରା ସେ ସରପଞ୍ଚ ଦେଖିଲେ ଏଠି ଲେଖା ହେଇଛି
ନା ଇଏ ହଉଛି ସୋରିଷିଆପଦାର
ହେତେ ଏଠିକି ଆସନ୍ତୁ PW4 ଆପଣ ଯୋଉ PW5 କହୁଛନ୍ତି ତ
ଆଜ୍ଞା
ହଁ PW5 ରେ ଦେଖୁନାହାନ୍ତି ଲେଖା ହେଇଛି ପୋଲିସ ଷ୍ଟେସନ ଗଣ୍ଡିଆ
ସିଏ ଆଜ୍ଞା ସୋରିଷିଆପଦାର ସରପଞ୍ଚ ସେ ହଉଛି ସରପଞ୍ଚ ହଉଛି ସୋରିଷିଆପଦା ଗାଁର ସୋରିଷିଆପଦା ଗାଁର ସେ ହଉଛି ସରପଞ୍ଚ
ଥାନା ଅଣ୍ଡରରେ
ଆଜ୍ଞା
ମନେକର 5-6ଟା ସାହି ବସ୍ତି ଭଳିଆ ଥିବ
ଆଜ୍ଞା
ହେଲା ଲେଟ୍ ଅସ୍ ସେ ଏକ୍ସାମ୍ପଲ ହଉଛି ଗୋଟେ ମନେ କରନ୍ତୁ ଚାଉଳିଆଗଞ୍ଜ ପୋଲିସ ଷ୍ଟେସନ ଅଣ୍ଡରରେ ବହୁତ ଜିନିଷ ଆସୁଛି ମହାନଦୀ ବିହାର ଆସୁଛି ତ ଅପର୍ଣ୍ଣା ନଗର ଆସୁଛି ଚାଉଳିଆଗଞ୍ଜ ଆସୁଛି ବିଦ୍ୟାଧରପୁର ସେ କହିଲା ଏଇ ଚାଉଳିଆଗଞ୍ଜର ଲୋକ ତେଣୁ ଚାଉଳିଆଗଞ୍ଜ ଟା ଗୋଟେ ନିର୍ଦ୍ଦିଷ୍ଟ ଜାଗା ନୁହଁ ଚାଉଳିଆଗଞ୍ଜ ଏରିଆଟା ହଉଛି ଗୋଟେ ଭାଷ୍ଟ ଏରିଆ ହେଲା ସେମିତି ଏଇ ଯୋଉ ଗଣ୍ଡିଆ ପୋଲିସ ଷ୍ଟେସନର ଗୋଟେ ପାର୍ଟଟା ହଉଛି ସୋରିଷିଆପଦା ତେଣୁ ସିଏ କହିଲା जे एतला किए लिखिला ना से गंडियार लोकटे लिखिला गंडिया भीतर जदि सुरिशिया पदा नथांता ताले आपण सबमिशन टा ठीक ही था
No, FIR not a single line stated regarding that. Neither neither the scriber of FIR was mentioned in the FIR mail. Neither the scriber of the FIR was mentioned in the FIR. Have a glance on the FIR first thing. वो जगह रे लिखा ही नहीं जे ये लिखिला बोली.
ये तो कहूची आपण कोन कोन तांकु कोन चैलेंज करछंती आपण व्हाट इज द योर क्रॉस एग्जामिनेशन ऑन दैट पॉइंट
Para 6, my lord. Have a glance on para 6, my lord. Para 7, my lord. Para 7, sorry. PW1, para 7, my lord. I had not accompanied to my brother to the hospital and remained at the village. After some time on the same night, I came to the hospital, and when the doctor declared my brother dead, I went to the PS, lost the affair. On the night of the occurrence day at about 8:30 p.m., I lost the affair. When I lost the affair, my brother was alive. The scriber of the affair is a shopkeeper, my lord. Having his shop in front of Gondia police station on the date of registration of the case, I was examined by the police so and so. I stated, my lord.
Yes, anything else?
I think the seizure witness also not supported. PW3 and 6 also not supported the prosecution case, my lord.
Yes, Mr. Pradhan, what do you say? What is your submission?
Solution of PW one will be different solution, the land dispute, PW three will be the political liability. Different solutions are there.
Okay, no, what is your answer to the comment which has been made on the evidence of PW3? You have to reply as per the submission which are made by the learned counsel for the appellant. You have to meet it. You say that PW3 has stated that during course of occurrence, the accused beat him on the right hand by his teeth. And if that thing happened, then it was expected that he should have received some injury on his right hand. But the doctor who examined PW3, is PW7, has noticed only two abrasions. One abrasion is on the right forearm, and the other is on the interscapula. That is so there is no teeth mark on that.
No teeth. It's a PW3, specifically stated that hero dealt a blow with that wood at the head of Madhav, causing bleeding injury.
जने कामुड़ी देले जो इंजुरी टा हबो सेटा जदि बेसी प्रेस करिवो ट्रीट मार्क हबो जदि कम कामुड़ी देला ताले कोन हबो जानि छथि मेडिकल jurisprudence whether abrasion can be found in such a state or not जो टाइप रो केन कामुडन घसी पड़ेला तो जने प्रेस करिवो जदि कामुडियो ताले दांत दागर एंती तोड़ कोरियन बाहर कर देला एंती टाइप रो है
And there was a scuffle, and both of them were in the fit of anger. It is not expected that he will just put the teeth on the hand of the person lightly. He must bite it to the maximum force. So obviously, when a person speaks that there is a bite by teeth, there must be some injury. But here there is no injury.
So her submission is that if that is not there, then the person which she is telling how it can be acted upon. What is your submission to that? You are to meet each of the contentions he has raised. He says, you see, so far as the FIR is concerned, the FIR does not indicate that anybody has scribed the FIR. Okay. On the body of the FIR, is there anything that lekhak hochi amko? Scribe ro na written report re nahi. Prosecution case hochi scribe hochi PW5. Right. Sarpanch hochi PW5. Now PW5 ro evidence ku jodi apono asibe se paragraph number 5% se kon hochi page number 48 ro
PW1 कहया अनुसार से लिख लेवल पूछे
से कहूची जे मु paragraph 3 रे कहला जे मु रिक्वेस्ट कला मते PW1 मु लेखिली एतलाडा paragraph 3 रे कहला एवं
requested by Sulabh Pradhan.
That is PW1.
हाँ PW1
Inform.
Sulabh Pradhan is PW1. Paragraph 5 रे कहूची जे I met Sulabh कोठी meet कला at Gondia in a motorcycle showroom where I was repairing my motorcycle. Now you come to PW1. Paragraph number 7. Page is 34. Last line पढ़ंतु.
I had not accompanied my brother.
No, paragraph number 7. हाँ ସେଇଟା ପଢ଼ନ୍ତୁ ଯେ तार last line टा पढ़ो ସେଇ page रो.
I lost the FIR. When I lost the FIR, my brother was alive.
तापरे
This describe of the FIR is a shopkeeper. Having is shop in front of Gondia police station. On the date of registration of the case, I was examined by.
ମାନେ scribe of the FIR ହଉଛି ଗୋଟେ ଦୋକାନୀ ଯାହା ଦୋକାନ ଥିଲା କୋଉଠି ନା ଗଣ୍ଡିଆ ଥାନା ସାମ୍ନାରେ ମୁଁ ସେଇ ତାରିଠୁ ଲେଖେଇକିନି ନେଇକିନି
In front of the police.
police station ରେ ଦେଲି 5 number ସାକ୍ଷୀ କହୁଛି scribe କହୁଛି ମୁଁ ମୋଟରସାଇକେଲ ଦୋକାନରେ ମୋଟର ରିପେୟାର ସାଇକେଲ ରିପେୟାର କରୁଥିଲି showroom ରେ ସେତିକିବେଳେ ଇଏ ମୋ ତା ସାଙ୍ଗରେ ଭେଟ ହେଲା ଏବଂ ତ ଲେଖକର ନାଁ ଦେହରେ ନାହିଁ ସେ କହୁଛନ୍ତି ଏଟା ଗୋଟେ ସସ୍ପିସିୟସ୍ ଫିଚର ହଉଛି ହ୍ୱାଟ ଇଜ ୟୁର ରିପ୍ଲାଏ ଟୁ ଦ୍ୟାଟ୍ and this witness PW6 in the chief examination has stated that one blow was given. Paragraph number 2, page 50. Right? Paragraph number 2, suddenly Kirod dealt a blow to Madhav by wooden plank held by him. Madhav sustained the injury and fell down. ହେଲା ତାପରେ ଯେତେବେଳେ ମୋ ବାପା when Madhav fell down sustaining my father Sanatan Sanatan is PW3 tried to prevent the accused assaulting further to Madhav, but the accused chased to assault my father. The accused dealt blows to my father which hit him on the back and bottom. My father captured the accused by embracing him and accused beat my father on the hand by teeth. ହେଲା ତ ଗୋଟିଏ ବ୍ଲୋ କଥା କହୁଛି ଯେ ଯୋଉ deceased କୁ ଗୋଟିଏ ବ୍ଲୋ ଦିଆଯାଇଛି only one, right? In the cross examination he has stated
3 to 4 blows.
That 3 to 4 blows. The first blow was given on the back, and when Madhav fell down, the other blows were given. So it may go accused 3 to 4 blows was given. ତେଣୁ ତାଙ୍କର submission ହଉଛି ଯେ how this person can be relied upon. In the chief examination, he says only one blow. And one blow after the deceased fell down. Then the PW3 intervened and he chased PW3 tried to assault him, and thereafter he was captured, or the appellant was captured. That means there is no other blow. But again in the cross examination it says that he fell down and thereafter other blows were given by the accused. So how can this man be said to be a truthful witness? Chief examination ने गोटे ब्लो देखिनी से पड़ेला
Cross record the
3-4 ब्लो से लोको को आपण गोटे ट्रुथफुल विटनेस पाई परिवे कि से ता सबमिशन होची से
with no preparation.
different. PW6 ରେ କୋଠି ଯେ chief ରେ କୋଠି ଗୋଟେ ବ୍ଲୋ
तार इफेक्ट ता कोन बा मु कहू म चीफ रे जणे कहला गोटे ब्लो दिया हला क्रॉस एग्जामिनेशन ने कहला 3-4 ब्लो आज्ञा देइछंती ए भलिया जदी गोटे स्टेटमेंट जणे विटनेस दिए ताहले से विटनेस टा को से विटनेस टा सत्य कहूची कारण विटनेसेस आर दी आईज एंड इयर्स ऑफ द कोर्ट से तो जगह नथिला ना तेणु कोर्ट रो देखिबो विटनेस जदि ट्रुथफुल थिबे तार वर्सन को एक्सेप्ट करिकिनी कोर्ट ये करियो तेणु जो विटनेस चीफ रे कोची गोटे ब्लो दियाला विटनेस पड़ी गला तापर आ कोनोसी ब्लो दियाइनी किंतु क्रॉस एग्जामिनेशन रे कहूची जे 3-4 ब्लो पड़िला परे मध्य से आ 3-4 ब्लो ताकू दिया हला other blows were given 3 to 4 blows were given on the head of the accused on the head by the accused तेणु ए विटनेस को कैटेगरी रे आसीबो witness टाको तीनिटा category रे divide कराइची गोटे होची wholly reliable गोटे wholly unreliable और गोटे partly reliable partly unreliable so wholly reliable witness टाको कहउचंती you can accept even there is no corroboration the court can place implicit reliance on it wholly unreliable discard करबो जोड़ा को partly reliable बा partly unreliable थिबे सेति पई corroboration court को देखिवा दरकार who source who may be from the medical evidence ru आसीबो बा अन्य evidence ru corroborating जदि आसीबो ताले still then that witness can be acted upon e जो type रो witness PW6 को आपण ए तीनिटा category रो को category भितर आनिबे whether he is wholly reliable or wholly unreliable or partly reliable partly unreliable partly आपण justify करियो ना आपण कोई भी खाली कोई दिल होबो you are the state council he is making some submission and we are also asking some questions to you you are to answer our query you are to defend that yes this conviction is justified and the sentence imposed is also justified so
there are so many questions before you first the witnesses are not wholly reliable at least PW6 PW3 is not reliable according to her the FIR has not been tried by PW5 but a shopkeeper who was found in front of the police station so there is a exaggeration in the fact so all these things have to be answered
who has written the FIR is doubtful
not there
because he says that somebody was in his shop in front of the police station. I scribed the FIR and presented that in the police station. That is the informant's version.
Then
The-
shopkeeper.
Your that shopkeeper, who is that shopkeeper? Because the scribe in this case, which the prosecution examined, he is the sarpanch, and he says that I was in a motorcycle. There I met the informant. So if the informant he met and so wrote the FIR, then which FIR was presented? Whether the FIR which was written by that shopkeeper in front of that Gondia police station, or that was written by the that sarpanch in that motorcycle shop. See, unless you go deeply, unless you prepare, but tomorrow, no. Taking time is not a situation. You are arguing a 302 case in the highest court of the state, and this proceeding is being live streamed. Just don't forget about it. So the students are watching, the judicial officers must be watching it during, so many persons. So they must be watching how the counsel are performing, how the court is posing the question, how the counsel is answering. So they may be learning many things from during this interaction. So you should match that standard. Your preparation should be up to that standard. Okay. And you go through this decision. We take up this matter tomorrow. Okay. All right. That's all for.